mayo.
Ladies and gentlemen, we will begin our hearing. Please stand the court.
It's an honor to open the hearings on the request for advisory opinion on the climate change and human rights of this 166th ordinary session of the Inter-American Court of Human Rights. On behalf of the court, I would like to express my sincere gratitude to the government of Barbados and the University of West Indies for their substantial support for this ordinary session. Hereon, I will conduct the rest of these proceedings in Spanish.
Good morning, everyone. We open this public hearing on the request for an advisory opinion submitted by the Republic of Chile and the Republic of Colombia on the climate emergency and human rights. As per resolution on 22nd of February 2024, this hearing shall be held between the 23rd and 25th of April in Bridgetown, Barbados, and it shall be followed by a second hearing scheduled to take place in Brazil in two parts on the 24th of May in Brasilia and from the 27th to the 29th of that same month in Manaus. These public hearings have the purpose of establishing a direct, diverse, and participatory dialogue to contribute and help inform the court and have relevant information to resolve the advisory opinion. In this sense, the court has considered it fundamental to hold sessions outside its seat to come closer to the realities of regions that have been severely affected by the impact of climate change, such as small island states in the Amazon region. I wish to especially thank the states and the international organization organizations, as well as the more than 600 organizations and academic institutions, and the dozens of communities and people from civil society who have participated in the written procedure. Likewise, I extend an acknowledgement on behalf of the court to all those who are joining us in person today at this first part of the public hearing, and those who have confirmed their participation in the hearings to be held in Brazil. Thanks to all of you, we are now in the midst of the public hearings with the largest and most broad participation in the history of this court. This confirms the participatory nature and the democratic nature of the creation of advisory opinions by the Inter-American Court, which is vitally important in such a fundamental issue as the one we're facing today. I wish to also welcome the delegations of all participating states, to ambassadors to the Inter-American Commission on Human Rights, represented by its president and vice president, to organizations of civil society, state organizations, universities, experts, and the rest of our participants. I also wish to greet the general public joining us in person, and most especially the students coming from different regions and universities of the world. I also wish to greet those following us by social media through our virtual platforms. I now give the floor to the registrar to provide the relevant instructions on the rules for this hearing. Thank you, Madam President. Those wishing to take pictures have 3 minutes, after which they must leave the stand. We also ask all those here present in the hearing to please turn off your cell phones. This hearing is being live streamed over the Inter-American Court of Human Rights social media. The Republic of Chile and the Republic of Colombia submitted a request for an advisory opinion on the climate emergency and human rights. As per Article 73.1 of the Rules of Procedure of the Court, this request was conveyed to all member states of the Organization of American States, the Secretary General of the OAS, the Chair of the Permanent Council, the Inter-American Commission on Human Rights, and other bodies of the OAS, as well as different international organizations, state organizations, international agencies, and national associations, non-government organizations, academic institutions, and the general civil society. They were all informed, as per Article 73.2 of the Rules of Procedure of the Court, of the term established for submitting written observations on the points sent for consultation. A total of 265 written observations were received. Through resolution of the 22nd of February 2024, the President of the Court convened member states, OAS bodies, and those who submitted written observations to the public hearing, so they may present their oral arguments and observations. This morning, we have appearing before the court the requesting states. On behalf of the Republic of Chile, with a delegation comprised of Sebastián Calcevich, permanent representative of the Chilean mission to the OAS, Julio Cordano, Director of Environment, Climate Change and Oceans of the Ministry of Foreign Affairs, Catalina Fernández Carter, Head of the Department of the Universal System for Human Rights, Oliver Roman López Serrano, Head of the Department of the Inter-American Human Rights System, and Patsy Nicole Contardo Urra, Technician in charge of the Division on Environment, Climate Change and Oceans of the Ministry of Foreign Affairs. On behalf of the Republic of Colombia, we have Mr. Luis Ernesto Vargas Silva, Agent and Ambassador, as well as Permanent Representative of the Republic of Colombia to the Organization of American States. Andrea Jiménez Herrera, Advisor of the Ministry of Foreign Affairs, and Juan Sebastián Villamil, Counselor and Advisor of the Permanent Mission of the Republic of Colombia to the OAS. In this hearing, we also have the following states. The Republic of Barbados, on this occasion, with a delegation comprised of Donna Ford, Representative and Director General of Foreign Affairs and Foreign Trade of Barbados, Robert Volterra, co-agent. Gunjan Sharma, counsel and partner at Volterra Fietta. Dale Marshall, Attorney General and Minister of Legal Affairs and Senior Minister of Political Governance. Anika Jackson, Solicitor General. Justice Christopher Blackman. Vian Best, Principal State Counsel at the Office of the Director of Public Prosecutions. Sean Jones, State Counsel of Public Prosecution. Rico Yearwood, State Counsel of Public Prosecution. Ricardo Marshall, Director of the Roofs to Reefs program in the Prime Minister's Office. Leo Brewster, Director of the Coastal Zone Management Unit of the Blue and Green Economy Division, Ministry of Environment and National Beautification. Chilean Cox, Chief Fisheries Officer of Blue Economy Division, Ministry of Environment and National Beautification. Travis Sinclair, Senior Environmental Officer, Ministry of Environment and National Beautification. Tyrone Brathwaite, Acting Senior Foreign Service Officer, Human Rights and Multilateral Division of the Ministry of Foreign Affairs and Foreign Trade. Joyce Grisette, Foreign Service Officer of the Human Rights and Multilateral Division of the Ministry of Foreign Affairs and Foreign Trade. Corey Archer, Foreign Service Officer of the Human Rights and Multilateral Division, Ministry of Foreign Affairs and Foreign Trade. Latoya Archer, Foreign Service Officer of the Human Rights and Multilateral Division of the Ministry of Foreign Affairs and Foreign Trade. Nicole Paris, Counsel of the Ministry of Foreign Affairs and Foreign Trade. Stephen Carrington Henry, Counsel of the Ministry of Foreign Affairs and Foreign Trades, and Florentine Voss, Counsel of Volterra Fietta. We also have appearing before us today the United Mexican States, the delegation comprised of Alejandro Celorio Alcántara, legal consultant, Miguel Ángel Reyes Moncayo, Deputy Legal Consultant, Alfredo Uriel Pérez Manriquez, Director for International Courts and Organizations of the Legal Consultancy, and Rubén Darío Álvarez Ángeles, Deputy Director on International Humanitarian Law and International Courts. We also have with us a representation by the Republic of Vanuatu, comprised of Margareta Weber-Nike Singh, attorney, and Leanne Scattert, legal advisor. We also have before the court for today the following delegations: the Inter-American Commission on Human Rights, with a delegation comprised by Roberta Clark, President of the Commission, Carlos Bernal Pulido, Vice President of the Commission, and Javier Palomo Lantes, Special Rapporteur on Economic, Social, Cultural, and Environmental Rights. And in representation of the Special Rapporteurs of the United Nations on Toxics and Human Rights, on Human Rights and the Environment, and on the Right to Development, Mr. Viren Mascarenhas. We also have appearing before the court today delegations of the Sabin Center for Climate Change Law, of Columbia Law School, and the Inter-American Association for Environmental Defense, AIDA. I ask all those who will be speaking today to please, during your presentations before the court, to express yourselves slowly and clearly to ensure we have smooth interpretation and to respect and keep to the times allotted. Likewise, whoever will be using the floor, please identify yourselves before the court and then proceed. Thank you, Madam President. Thank you, Mr. Secretary, and considering all the order established by the Secretariat for this first day of the hearing, I now give the floor first to the representatives of the Republic of Chile. Go ahead.
Señora
Madam President, honorable judges, registrar, and staff of the Secretariat of the the Inter-American Court of Human Rights, representatives of the states, international and non-governmental organizations, academic institutions, civil society organizations, and individuals. I have the honor to participate in my capacity as permanent representative of Chile to the OAS. In early 2023, our country, together with Colombia, submitted a request to this court for an advisory opinion to interpret the obligations of states parties to the American Convention on Human Rights in the framework of the climate emergency. The concept of emergency, which is part of the title of this process, is not there by chance and is not a hyperbole. We are living in an era which, as the Secretary General of the UN said, is no longer one of global warming, but of global boiling, which has a major impact on the enjoyment of human rights, including the existence and subsistence of millions of people. The impact of this emergency is not the same for all. It is especially devastating for children, indigenous peoples, farmer communities, and women and others. This fact has been proven by the scientific community. The world is faced with a catastrophe. This court now has to define the legal consequences stemming from this fact. The global crisis, the crisis is global, but placing it in the Americas is important. The Caribbean, which is where we are now, as well as South America and Central America, are highly vulnerable in human terms. We are affected in a way that is disproportionate to the responsibility of our communities in generating this emergency. The above doesn't mean that our region and the states parties to the American Convention are exempt from obligations in the face of this crisis. That is why, as you can see in our written submissions, Chile is facing its challenges in both domestically and internationally progressively. In 2020, Chile updated its NDC, including a new pillar having to do with SDGs and contemplating a fair process to decarbonize the power grid. In 2021, we submitted our long-term climate strategy, and in 2022, as soon as President Boric took office, we acceded to the Escazú Agreement. Domestically, in 2022, we enacted a framework law on climate change, which, amongst other things, seeks to transition to a development that is low in greenhouse emissions and also climate forces in order to attain carbon neutrality by 2050 and adapt to climate change and make international commitments binding. But the needs faced by our states in the different areas of the climate emergency are overwhelming, especially when added to the challenges that all developing countries face: healthcare, education, pension systems, labor, etc. Honorable Court, this climate emergency calls for cooperation by all of the international community. The actions in Latin America and the Caribbean, even the most ambitious of them, will have very limited effects on climate change unless they are accompanied by actions by the global emitters and polluters. This makes it especially important for this honorable court and other international courts to provide guidance on how states should act. And this is why, having in mind the elements already included in advisory opinion OC 2317 on the environment, this court is faced with the opportunity to continue to develop its obligations, elaborate on the obligations on states in face of this emergency. I'd like to thank you for your attention, and I now give the floor, if it pleases the court, to Ms. Catalina Fernandez Carter to proceed with the second part of our presentation. Thank you, Madam President, honorable judges of this court. I'm Catalina Fernandez, and it's an honor for me to participate on behalf of the state of Chile in this advisory proceedings. As Ambassador Krajlevic already said, the questions before this honorable court are very relevant, and the catastrophe is such that it's not an exaggeration to say that facing the climate crisis is necessary to guarantee the survival of humankind, as was recognized by judges Perez Manrique, Ferrer MacGregor, and Mudrovich in their concurring opinion in the case of La Oroja versus Peru. Today, I will not be able to address all 19 questions contained in the request or all the aspects that are included in our written submissions. In the interest of time, though, I would like to focus on three aspects. Number one, The global climate regime that is applicable in this case to the obligations of prevention and mitigation of the states, incumbent upon the states before the climate emergency. And three, the obligations that are incumbent upon all states, including medium-sized and small states, to take a urgent action, adaptation action, bearing in mind especially groups that have been historically excluded and disenfranchised. Honorable Court, first of all, I'll refer to the global environment regime. As was said in our written submissions, Chile believes that an analysis of the obligations of the states in the face of the climate emergency in light of the American Convention calls for this to be borne in mind. And this includes the Framework Convention on Climate Change and the Paris Agreement. Chile, therefore, considers that the principles enshrined in those documents can help this court. Principles such as intergenerational equity, common but differentiated responsibilities, the acknowledgement of needs and specific needs and circumstances of countries, precautionary principle, the adoption of cost-effective policies and measures, as well as mainstreaming this into all economic sectors, as well as international cooperation, are directly relevant principles to answer these questions that must be added to other principles that have been recognized by this honorable court in the area of human rights, such as the pro persona principle, non-discrimination, the overarching interest of children, non-regression, transparency, and citizen participation, just to name a few. At the same time, this honorable court must be reminded that the global climate regime has clearly specified the provisions that are obligations as such, and which are voluntary commitments. And it has also underscored the difference between the various obligations falling to developed states on the one hand and developing states on the other. This leads me to my second point about the state's obligations when it comes to prevention and mitigation. In that regard, in its advisory opinion of 2017, this court recognized the fact that states' jurisdiction and their obligation to protect human rights extends beyond its borders, and that states may be found responsible for significant damage caused to persons who are outside of their borders by activities under their jurisdiction, regardless of whether they are legal or illegal. As part of the global climate regime, these duties are part of mitigation. Here, the court faces a paradox, however. International instruments, those that I have just mentioned, do recognize that climate change is a common concern for humankind. And they do include a collective commitment on the part of states to limit the increase of global temperatures. However, these instruments do not establish an obligation above and beyond the submission and updating of NDCs. What is even more crucial, the implementation of these nationally applicable instruments is not enforceable, and there are no standards allowing for for it to be ascertained whether these are fit to face a climate emergency, not at the state level, not collectively. And this is something that must be addressed by the court in view of the uncertainty in this area. Advisory opinion can provide much needed clarification about the measures that must be taken by states individually and collectively, bearing in mind the national circumstances of each state and what their contribution is to climate change. In third place, I'd like to refer to adaptation to climate change. In this respect, the Inter-American Commission on Human Rights in Resolution 3/2021 recognized that the implementation of adaptation measures should not be overlooked due to the multi-causal nature of the climate crisis, since all states have shared, common, but differentiated obligations in the context of climate action. Similarly, the European Court of Human Rights recently, in a case against Switzerland, said that effective protection of the rights of persons does call for states to carry out measures to mitigate the most serious and imminent consequences of climate change, bearing in mind any specific needs for protection that is relevant and must be established effectively in keeping with the best evidence available. The global climate regime can also help this honorable court when it comes to adaptation by addressing both the substantive and procedural aspects. The Paris Agreement in Article 7.5 refers to the fact that adaptation action should follow a country-driven, gender-responsive, participatory, and fully transparent approach, taking into consideration vulnerable groups, communities, and ecosystems, and should be based on and guided by the best available science and as appropriate traditional knowledge of indigenous peoples, and local knowledge systems. That's nothing new for a region. The Escazú Agreement was groundbreaking in doing so. And recognizing environmental transparency and information and participation. But there's a need to bear in mind for adaptation what the geographic context is, as well as social and cultural for each country in keeping with the Paris Agreement. Chile has developed a national adaptation plan with sectoral plans, all of which are either under review or have been updated through a participatory process and with local relevance. Other such plans have also been implemented by countries in the region. Also, cooperation and funding for adaptation by developed countries, which are listed in Annex 1 of the Convention, is an obligation for them, having to, with a need to consider the priorities and needs determined by the countries that are receiving such support. So Chile requests that this court recognize that climate change adaptation creates an obligation for states parties to the convention to have geographically, socially, and culturally relevant plans and adaptation plans and actions and for developed countries to mobilize resources, transfer technologies, build capacities and other measures. Also, in 2016, in the case of the Fazenda Brasil Verde, the court said that every person who is in a situation of vulnerability is entitled to special protection, and this principle is also applicable when it comes to adaptation. As we said in our written submissions, the specific needs of children, indigenous populations, farmer populations, women, human rights defenders, just to name a few, requires that states take differentiated protective measures with an intersectional and gender-based approach. Honorable Court, in conclusion, Chile recognizes that the task faced by this court as part of this advisory opinion is daunting, and that is why we would like to thank you for your willingness to consider the various questions that have been asked. This process comes in addition to those of other international courts, but there is a need for coherent interpretation amongst them. However, the role of this honorable court is particularly important. Addressing this issue with a human rights perspective will help have a fair and effective response to the climate emergency, and is become a galvanizing element for civil society, and has been a basis for civil society and also a basis for rulings, laws, and public policy. Faced with an international system that sometimes is flawed and has shortcomings due to the lack of enforcement mechanisms, this advisory opinion will be essential for the domestic jurisdiction and will help find responses that are timely, relevant, and long-lasting. Thank you all for your attention.
El Estado de Chile.
Thank you, State of Chile. We will now hear from the representatives of the State of Colombia. Please proceed. Thank you, Madam President, distinguished judges, and personnel of the Secretariat of the Inter-American Court of Human Rights, representatives of the states and bodies of the OAS, international organizations, non-governmental organizations, academic and organizations, and civil society. It is an honor to come before this distinguished court and speak on behalf of the people of Colombia. The importance of the advisory opinion requested by Colombia and Chile is due to the fact that the current climate crisis has a significant impact on the ability of people to enjoy their human rights to life, personal integrity, a healthy environment, and other rights such as decent housing, sufficient nutrition, health, water, and cultural rights. This situation comprises significant damage according to the case law of this Inter-American Court of Human Rights and other international oversight bodies. Therefore, the lack of measures to prevent damage to these rights or to regulate activities that would contribute to this damage may undermine the state's obligations to human rights. In the context of measures for mitigation and prevention of the risk of significant damage to the environment, it is essential for the states to meet their international obligations for prevention, precaution, and good faith cooperation. If they do not, the states would be violating their own duties, and the repercussions would reach beyond their own territory. The greatest challenge of this situation is that it does not recognize borders. Instead, it affects all of the human race, with a special impact on especially vulnerable population groups, those that are especially exposed to be affected more earlier and more severely. In order to overcome the situation, there is an absolute duty for the nations to cooperate together through multilateralism and international environmental law in order to find joint solutions, led by the principle of common but differentiated responsibilities, just cited by Chile. This court must urge the states to implement measures swiftly and effectively to conserve, protect, and restore the integrity of the environment and its ecosystems, recognizing and assuming responsibilities that are proportional to the capacity of each state, with an eye to preventing any perpetuation of violations of human rights. This court's opinion will have an impact on management of the climate emergency by the American states by setting guidelines by which the measures to be adopted domestically would be consistent with the international obligations of the American states. This advisory opinion would therefore stand as a landmark in the inter-American human rights system, which would guide judges at every level, addressing the enforceability of obligations and for violations of human rights threatened by the climate emergency. The impact in Colombia. Colombia is a water-based country. More than 30 million hectares of our land are marine territory. And a variety of cultures live in and depend on this resource. It is a country that brings together all of the ecosystems of South America, including the Caribbean, the Pacific, the Andes, the Amazon, and the great watershed of the Orinoco River. More than 59 million hectares of our country have lost their environmental or ecological integrity, and this has made these ecosystems especially vulnerable, particularly in regions such as the Caribbean and the Andes, which are those regions of Colombia that are especially susceptible to climate phenomena such as the El Niño and La Niña currents. As President Gustavo Petro recognized recently, the effects of climate change are being felt acutely in our country. Even as we speak, the critical loss of our water supplies in a number of the major cities, and particularly in the capital city of Bogota, is a direct result of rising temperatures and recent droughts. Colombia may also experience the loss of its snow caps and the effects of rising temperatures in regions of great biological diversity, such as the Amazon region, the Orinoco River, and the Pacific. If we do not take swift, decisive action, the damage will become irreversible. The rising sea levels even more quickly than the global average, together with lengthy intense drought, have become a critical problem. This phenomenon is eroding our coastlines, having an impact on areas that have served as the foundation of the livelihood for local communities for generations. Moreover, the frequency and intensity of extreme climate events because of rising marine temperatures, bleaching of the coral reefs, producing the loss of diversity in these ecosystems, are worsening the crisis. This is particularly visible in the island territories, such as in Colombia, the archipelago department of San Andres, Providencia, and Santa Catalina, which are highly at high risk because of climate change. In the archipelago, the adverse impact of climate change has a particularly severe impact on fishing and agriculture by the Raizal tribal community. What are the most vulnerable populations? Colombia recognizes gender-based differentiated impact because of the climate emergency. Women face additional barriers in terms of access to education and health care in the context of the climate crisis. Colombia makes a call to this court so that in its advisory opinion it would address these disparities, promoting gender equality in the context of climate change. In the framework of COP27, the first gender and climate change plan of action of Colombia was adopted. This is a roadmap under which every action to reduce greenhouse gases and adapt to climate change would effectively include a gender approach, including ancestral knowledge held by rural women. Building this roadmap included participation by farm women leaders, Afro-Colombian women leaders, and indigenous women leaders throughout the country. With respect to the indigenous peoples, Raizal tribal groups, and Afro-descendant communities, we cannot ignore the fact that their territory and way of living is severely jeopardized by the climate emergency as a result of environmental degradation and loss of biodiversity. These communities have a deep ancestral connection to nature, and the environment where they have traditionally lived not only makes them more vulnerable to the impact of climate change, but also jeopardizes their historical, cultural, and collective rights. Colombia would also reiterate the need to develop policies and mechanisms for protection that would address the specific needs of populations that have been affected by dynamics of human movement, such as migrants, displaced persons, and refugees. In the context of the climate emergency, we absolutely need an international legal framework by which the states would adopt measures to extend suitable human rights protection to people who are involved in these dynamics of human mobilization for reasons of climate, that is, climate the climate-based displaced persons. Together with this, in Colombia, there is a large number of human rights defenders with an environmental focus who day by day are battling in their regions to protect their land and natural resources affected by the climate crisis. Colombia, like the other American states, has the particular duty to protect this group of people, to facilitate the resources they need to conduct their activities freely, to protect them when they are subject to threats, in order to prevent any threats against their lives and safety, and refrained from setting up any obstacles that would make it difficult for them to do their work. What is Colombia doing with this situation? Through the 2022-2026 National Development Plan, Colombia has set about transforming land management practices concerning water, along with environmental recovery of lost nature and to put a stop to deforestation. This development plan also calls for working toward land management processes to be consolidated as a collective institution built on the basis of environmental governance, taking into account the farmer communities and the ethnic groups, both in the design and in the implementation of the different land management instruments. Colombia is also working toward ratification of the Escazú Agreement to ensure that regional standards are set for access to information, public participation, and environmental justice, to include in our domestic land management processes the mechanisms that are inclusive, transparent, and have opportunities for appropriate participation, with particular attention to vulnerable communities, in order to meet the goal of reducing greenhouse gas emissions by 51% by 2030 and to achieve carbon neutrality in 2050. Based on the decision on the world balance of the United Nations Framework Convention on Climate Change, Colombia will implement a roadmap to develop its contributions set nationally, that is its NDCs, in order to stop using fossil fuels. These efforts that Colombia has undertaken show how climate action has become a national priority. The National Plan for Climate Change Adaptation includes strategies geared toward bolstering resilience by reducing and managing risk, by adaptation to change, and by mitigating the impacts associated with climate change that are already visible in Colombia, such as coastal erosion. Colombia is working to build sustainable peace that would bear in mind protection of the environment and sustainable management of natural resources, recognizing the close relationship between environmental degradation and armed conflict. Madam President, ladies and gentlemen of the court, the American states have the responsibility, and they cannot avoid it, to take urgent action in the face of the climate emergency, and in doing so to take into account the specific needs of vulnerable groups. Colombia therefore recognizes and emphasizes the work that the Inter-American Court has in its hands at this time, a responsibility that extends beyond the basic obligations of the states to respect, protect, and guarantee the human rights of all persons in their jurisdiction. In the context of climate change, the court must address this responsibility and the way it reaches beyond national and regional borders. It is essential for this court to intervene on an urgent footing to harmonize the obligations derived from the Inter-American human rights system and keep them in harmony with the obligations that arise from international environmental law, and thus definitively establish and show how the guiding principles of environmental law lead the countries to meet their environmental obligations, understanding that they are part of the worldwide of the global legal framework to prevent and mitigate the climate emergency based on the duties that are incumbent upon them to respect human rights. We are standing at a crossroads, a critical crossroads, in order to avoid this cataclysm, to ward it off. Once the advisory opinion has been issued, it will become a critically important tool to safeguard life on Earth. Madam President, you have recognized in the decision of February 22 of this year that this large number of interventions, all these that are at the highest level that the court has undertaken, creates a high priority for these interventions, so that these measures are adopted in territories where the impact has been felt. This is a call and a cry for these states to understand and to attach to their work the importance that it deserves. In the work that the American states have assigned this responsibility to the court, and we trust that you, ladies and gentlemen of the court, will shoulder this obligation and stand and break ground for the entire international community. Thank you, ladies and gentlemen.
Agradezco a la representación del Estado de Colombia su intervención.
Thank you for your intervention to the State of Colombia. And now I give the floor to representatives of the Republic of Barbados. Please go ahead.
Thank you. Thank you, Madam President. Madam President, honorable members of the court, I am Donna Ford, Director General of the Ministry of Foreign Affairs and Foreign Trade of Barbados, and it is my pleasure to welcome you to Barbados. I wish to thank you for coming to Bridgetown to hold this important case. While you're here, I hope that you will have the opportunity to visit Oistins, a historic place on our island. Oistins is a traditional fishing village less than 10 miles from here, and every Friday night, Oistins village is transformed and comes alive with food, music, dancing, and all that makes Barbados great for locals and visitors. This includes warm Bajan hospitality, great fish, calypso music, dancing, and friendship. Oistins is one of the keys to Barbados' greatest economic engine, which is, of course, tourism. And as you enjoy the food, dancing, and fun in Oistins this coming Friday, please remember this. Everything that Oistins represents from our past, everything that Oistins is in the present, and everything that Oistins promises Barbadians for our future is at risk of disappearing because of climate change. Because of climate change, Barbados' beautiful beaches are at severe risk of being submerged. Barbados' good food and infrastructure is at severe risk of being swept away by the tides. Our island's vibrant economy faces severe risk. Property and business insurance is becoming expensive and soon may become inaccessible. Climate change even threatens the production of the very sugar we need to produce our unsurpassed rums. And, as you can see on the slide, our sea level rise resulting from climate change is eroding significant parts of Barbados' world-renowned beaches. Barbadian fishing resources are also at risk due to the ecological damage wrought by climate change, and our crops, including our sugarcane, are becoming harder to grow. Climate change is increasingly making Barbados a location of extreme weather events. Historically, Barbados has not been prone to hurricanes or extreme weather because of our location at the eastern edge of the Caribbean. But in 2021, that changed. The island was hit by a tropical storm on the 17th of June, and then 3 weeks later, Hurricane Elsa landed. Barbadians suffered over $35 million in damage, and we and our neighbors across the Caribbean islands have been warned to expect more frequent extreme weather events because of climate change. Human-made climate change adversely affects all states, all peoples, and all ecologies worldwide. But states which lack physical resources and fiscal space to manage the impacts of climate change are the most vulnerable to its harmful effects. Ironically, those worst affected states are not the ones that cause climate change. Barbados is one of those states that did not cause climate change. Yet Barbados is, and is predicted to be in the future, one of the worst affected. And critically, Barbados lacks the physical and fiscal space to manage effectively the impacts of climate change. Barbados is proud to have taken on a global leadership role in confronting climate change. Barbados' Prime Minister, Honorable Mia Amor-Motley, has spoken on behalf of Barbadians and reflected the concerns of others around the world about climate change issues, including at the United Nations climate change conferences. Madam President, Barbados is participating in this proceeding before the court because we believe in the rule of law in international relations. Barbadians, like many millions of other people in the Americas and beyond, are looking to the court to identify the applicable international legal norms relevant to climate change that are binding on Organization of American States member states under the convention. Barbados is confident that the court will act in accordance with law and justice. Please do so quickly, because we cannot wait. I thank you for your attention, Madam President, and now respectfully ask the court to call upon my co-agent, Professor Robert Volterra, to particularize Barbados' legal submissions on the issues before the court. I thank you.
Madam President, members of the court, Barbados has instructed me to make this oral intervention. As ever, it is an honor to appear as counsel before this esteemed court. Barbados' submissions have addressed only question F of the request. Barbados has submitted observations only on this question because the answer to this one question explains all the relevant obligations relating to climate change under the American Convention. The answer to question F requires the court to identify 4 obligations under the Convention arising from climate change. These are the obligations to mitigate climate change, the obligation to adapt to climate change, the obligation to provide individual remedies for climate change in national legal systems, and the obligation on states whose conduct contributed to climate change to provide restitution to states that did not contribute to climate change and that do not have the physical or financial space to ameliorate its harms. Each of these essential obligations will vindicate the human rights obligations in the inter-American system, and each is required to do so. Barbados is particularly concerned to draw the court's attention to the 4th obligation on this list, and that will be the focus of my submissions today. It is critical to Barbados and other vulnerable states, because without this 4th obligation, the other 3 are meaningless. Meaningless insofar as resource-deprived, developing, and smaller states are concerned. It is an obligation which addresses the fundamental norms of accountability and the meaningful protection of the vulnerable, which are cornerstones of the inter-American system. The source of this legal principle is customary international law, including in relation to state responsibility for transboundary harm. As part of its analytical methodology, this court refers to and incorporates the entire relevant corpus of international law, including customary international law, in reaching its decisions. In the present proceeding, this methodological approach requires the court to recognize the international law obligations of states which contributed to climate change, to compensate those that did not, but that are nonetheless harmed by climate change and do not have the physical and financial space to ameliorate them. As the court will be aware, Barbados has analyzed this international law obligation under the Convention meticulously in its written submissions, and I direct the court to those observations. Resource-deprived, developing, and smaller states in the Americas, such as Barbados, cannot on their own ameliorate the consequences of climate change that have been effected on them by other states. States like Barbados lack the physical and financial space to do so. If the court, on the one hand, issued an advisory opinion that identified obligations on developing states to mitigate, adapt, and provide domestic remedies for the consequences of climate change, but on the other hand failed to identify the financial obligations of developed states which have contributed to climate change harm, to provide restitution for the harm caused by their conduct, then the court will have issued an opinion that imposes obligations on developing states that it knows those states cannot meet. If the court failed to identify the restitution obligation under the Convention as it relates to climate change, the advisory opinion would sidestep accountability. It would effectively be meaningless for the people of the resource-deprived, developing, and smaller states of the Americas, particularly small island states. It would be relevant only to people living in the large and wealthy states of the Americas. It would be a rich person's climate change advisory opinion. The people of Barbados and most of their Caribbean neighbors would be abandoned to suffer the consequences of the impending catastrophe on their own. Barbados is not asking the court to create new law or to engage in redistributive justice. Barbados is asking the court to identify international law as it exists today, and indeed as it has existed for centuries, as it has been set out in Barbados's written observations. Indeed, at paragraphs 137 to 146 of Barbados's written observations, you can see the analysis of the international law principle of sic utere tuo ut alienum non leidas. This Latin maxim identifies the international law prohibition on transboundary harm. This principle has long been a norm of international law, and the corresponding legal obligation to this, that corresponds to this, is that a state which fails to prevent transboundary harm must compensate the state that its conduct has harmed. This obligation is also long established and not controversial. The court can find this analysis at paragraphs 212 to 309 of Barbados's written submissions. In international law, this obligation to compensate is a strict liability. It's a strict liability on the state that has caused the harm. Barbados notes that the Republic of Colombia and the United Mexican States make the same observations in their written submissions. Thus, Barbados respectfully submits that this esteemed court must identify, in this advisory opinion, the interstate compensation component of the relevant relevant obligations under the Convention and as informed by customary international law. That is the law. An advisory opinion which does this will address issues of accountability and protection of the vulnerable in a meaningful way. It will have immediate and tangible benefits for the peoples of states that, like Barbados and many of its Caribbean neighbors, face an existential threat from climate change. I list just 3 of these benefits. 1, agencies of the OAS, the Organization of American States, will need to incorporate climate change restitution obligations into their projects and funding. This includes the Inter-American Development Bank, which will need to enable access to insurance for vulnerable states. A second benefit is that the court's identification of the compensation obligation under international law and the Convention will facilitate meaningful outcomes for developing states in their climate change negotiations with developed states. And third, the court's opinion on the obligation to compensate for climate change harm will undoubtedly be carefully considered by other international courts and tribunals that are currently also considering these issues. In the very recent case of Habitantes de la Oroya contra Peru, the court unanimously concluded that international law requires states to protect the environment. Barbados's written observations in these present proceedings contain more than 400 legal authorities which support that conclusion. Barbados hopes that these will assist the court to strengthen its correct identification of the jus cogens character of this customary international law requirement. Barbados also hopes that the legal authorities it has provided will assist the court in recognizing that a requirement under the Convention to protect the environment would be rendered utterly meaningless in practice without a concomitant requirement to compensate for climate change harm. I thank the esteemed court for its attention and ask it to call upon Mr. Gunjan Sharma, who's been instructed by Barbados to address the courts for 3 minutes on one important legal issue.
Madam President, members of the court, I thank you for the opportunity to make this intervention as counsel to Barbados. In this intervention, Barbados will show that the 3 major climate change conventions do not represent a complete lex specialis that limit states' obligations in respect of the climate crisis. Far from it. Instead, these 3 conventions supplement, they work with, relevant obligations emerging out of other sources of international law, such as customary international law and international human rights law. The 3 major climate change conventions are, of course, the 1992 UN Framework Convention on Climate Change, UNFCCC, found at Annex 50 to Barbados's written observations, the 1997 Kyoto Protocol to the UNFCCC at Annex 69, and the 2015 Paris Agreement at Annex 93. Not a single word in these conventions, not one word, suggests that they are intended to, or that they did, displace all other relevant sources of international law on climate change. The opposite is true. In fact, each convention accepts that states have other relevant climate change obligations outside of the convention's terms. For example, the UNFCCC's preamble, which also applies to the Kyoto Protocol, accepts the additional obligation of states not to cause transboundary harm under customary international law. It refers to the obligation of states, quote, I quote, to ensure that activities within their jurisdiction or control do not cause damage to the environment of other states, end quote. You will see that at Annex 50, page 166. The Paris Agreement says that states must, and I quote again, when taking action to address climate change, respect, promote, and consider their respective obligations, it uses the word obligations, end quote, under international human rights law and international development law. That language can be found at Annex 93, page 144. This precise language accepts and in fact endorses that states have obligations in respect of the climate change crisis beyond those set out in these 3 treaties. Indeed, when many states ratified these conventions, they made express declarations confirming that nothing in the conventions superseded or displaced obligations from other sources of international law. Such declarations were made by the Cook Islands, Marshall Islands, Micronesia, Nauru, Niue, Philippines, Solomon Islands, and Tuvalu in respect of the Paris Agreement. Those are annexes 170 to 178. Similarly, Fiji, Kiribati, Nauru, and Papua New Guinea made the same declarations in respect of the UNFCCC. For all these reasons, Barbados respectfully submits that this court should consider all the relevant obligations of states in light of the climate crisis, based on all the relevant sources of international law. I thank this court for its kind patience.
Muchas gracias a la representación.
I thank the representatives of Barbados for their presentation. I now give the floor to the United Mexican States. Madam President Nancy Hernandez Lopez, Honorable Court, representatives of the states, organizations, and all participants in this public hearing. My name is Uriel Perez Manriquez. I'm the Director for International Courts and Organizations with the Department of Foreign Affairs of Mexico. It's an honor to be here before this court to make our oral submissions on behalf of Mexico on the climate emergency and human rights. I'd like to start off by thanking Barbados for their warm welcome, and for hosting this session for the region and the world at large. We would like to thank Chile and Colombia for submitting this request, because we believe that the advisory opinion stemming from this proceedings will help states meet their obligations under the American Convention in the best way possible. As to the issue at hand, it is important to say that this court can also have a practical effect on obtaining care for the environment by considering in the future holding hybrid sessions so as to reduce the carbon footprint of the travel from delegations, and also thus allowing all to participate. Mexico attaches great importance to this issue. That is why between September 25 and 27, 2023, the Department of Foreign Affairs, together with the UNAM Legal Research Institute, coordinated a seminar, an international seminar on climate change, bringing together the scientific and legal community as well as civil society and the Mexican government for a discussion about the relationship between public international law, its various branches, and the climate emergency stemming from climate change. The comments that are in our written submissions are the result of the consultation process. If it please the court, I would like to speak on behalf of Mexico. In the interest of time, we will be focusing on a few of the topics and some of the components that are in the request for an advisory opinion. Honorable Court, the discussions about climate change have revolved around technical and financial aspects, overlooking the fact that a human rights and gender approach should be included as a basis for the creation of just and sustainable societies. One of the main challenges is to have a gender and human rights approach that is intersectional and meets the needs of vulnerable groups, that in taking into account their diversity. Our region has particularly suffered and directly suffered the impact of climate change. Our geography makes us more vulnerable to phenomena such as rising sea levels and average temperatures, and our biodiversity is put in special jeopardy. There is ample scientific evidence pointing to the way in which climate change affects all, but especially populations that, due to structural, social, and historical circumstances, are especially vulnerable. The climate crisis is even more evident and pressing when it comes to women, children, adolescents, and diverse populations, indigenous communities, and people living in poverty. It is fundamentally important for states to bear this situation, this vulnerability situation, in mind when meeting their obligations in regard to the protection of the environment. As to the first component in the request for an advisory opinion about the obligations of states and the duty to prevent. Mexico would like to say that state obligations in terms of climate change do not just refer to the actions carried out by the state itself. They also cover regulation and punishment of activities carried out by private entities that may have a negative impact on the environment, be it within or beyond their borders. States are under the general duty for prevention that extends to activities that may negatively and seriously affect the environment and the sustainable development of current and future generations. This duty of prevention is enshrined in customary international law. It has been mentioned by this court, by the European Court of Human Rights, and the International Court of Justice. In Mexico, our Constitution, in its Article 4.5, there is a right of every person to a healthy environment for their well-being and development, and that the state will guarantee respect for this right, and that any damage that is caused will lead to liability for whoever is responsible. The Supreme Court has said that this principle must guide the analysis and interpretation of the right to a healthy environment, and also the obligations to in terms of respect when it comes to climate change and the protection of the environment within our borders. This principle must guide us when it comes to interpreting constitutional provisions, international agreements, and other standards in the area. The Supreme Court has interpreted and applied the principle of prevention in several occasions, where it said that it's based on the knowledge of the fact that an activity or a specific situation may lead to risk for the environment, and therefore calls for actions to be taken to prevent damage from happening or the risk from materializing. That means that you first need to have an environmental assessment system. Secondly, create quality and emission standards which must be enforced, and also have an environmental responsibility regime, and also sanctions for the conducts that may be against them. As to the obligations to preserve the right to life and livelihood, survival in the face of the climate emergency, the right to a clean, healthy, and sustainable environment is interrelated with several rights, substantive as the right to clean air, drinking water, and sanitation, and also others that are procedural in nature, such as access to information, the right to participate in decision making, and access to justice and effective recourse and remedies. As was mentioned by the European Court in the recent decision, the Swiss Confederation breached its obligations when it came to climate change by not guaranteeing effective protection from the deleterious effects of climate change on life, health, well-being, and quality of life, and also for not guaranteeing access to the courts and to a fair trial. In Mexico, we have a general climate change law establishing that the measures to face this phenomenon must strictly respect human rights, the right to health, the rights of indigenous peoples, migrants, children, persons with disabilities, and persons in vulnerable situations. As to the third component, the differentiated impact of the climate emergency is a fact. It creates a risk for future generations to enjoy the natural resources and also have access to sustainable development and to their own human rights. The Paris Agreement recognizes that reality and refers to the principle of intergenerational equity. State obligations about the protection of the environment do have a preventive dimension, which is even more significant when it comes to children and adolescents. States are under the obligation to make sure that children and adolescents are in a position to be informed, form their own opinion, and be listened in decision making that will have a deep environmental impact. In Mexico, the National Protection System for the Protection of Children and Adolescents is meant to develop public policy at the highest government decision-making level with an approach that bears in mind and demands respect for the rights of these groups of people. As to the fourth component, there is an obligation for international cooperation between states parties to attain full effectiveness for human rights. When it comes to the environment, this obligation is enshrined in international instruments such as the Rio Declaration and the Paris Agreement. Environmental damage is usually cross-border, and that's why prevention and mitigation must happen in good faith and jointly by states. Mexico considers that the obligation of consultation is a fundamental component of good faith cooperation, especially when significant damage may occur to specific groups. It is necessary that before implementing projects that may have a cross-border effect and exacerbate climate change, states and groups that may be affected by such damage be notified, that there be consultation, and if necessary, negotiations be undertaken so as to reach an agreement about the alternatives that may be implemented to avoid negative effects for human rights. I'd also like to speak about the indigenous women and the protection of the environment. They have a clear link to their environment, their land, and their natural resources, as was said by the Committee for the Elimination of Discrimination Against Women in its recommendation number 39. Because of this direct link of respect, responsibility, and interdependence with nature, indigenous women have been able to acquire and perfect their knowledge, which help protect and manage the environment. Therefore, states must acknowledge the indigenous women and children and girls' contribution to conservation and restoring of biodiversity, including the decisions and negotiations, and also in debates about climate change mitigation and adaptation. The Regional Agreement on Access to Information, Public Participation, and Justice in Environmental Matters in Latin America and the Caribbean, the Escazú Agreement, is a pioneer in the recognition of these matters. As a show of political will to protect human rights defenders, Mexico ratified this instrument in November 2020. Finally, about shared but differentiated responsibilities, Mexico believes that different circumstances must be borne in mind, specifically when it comes to each state's contribution to speeding up and exacerbating a problem, and also its ability to reduce this threat. We believe that in order to apply this principle, there's a need to bear in mind technical and scientific aspects, financial situation, geographic location, and other factors and specific difficulties in order to identify each state's responsibilities when it comes to mitigating climate change. The Paris Agreement itself refers to the commitment by developed states to cooperate with developing states to address climate change effectively. In spite of this differentiated approach, we must always be reminded that all states are under obligations when it comes to human rights, and they must all exert or provide protection and guarantees according to international standards and treaties. Honorable Court, as I have said before, and as the State of Mexico underscored in its written submission, this advisory opinion is greatly important to ascertain what the state obligations are in terms of human rights in the face of one of the most pressing matters for the region and the planet, to wit, climate change. That is why we suggest that the Inter-American Court explore the possibility of dialoguing or conversing with other international courts, such as the International Court of Justice and the International Tribunal on the Law of the Sea, that also have an advisory dual advisory group. The Tribunal on the Law of the Sea will issue an advisory opinion on May 1st, whereas the proceedings before the International Court of Justice are still in its read-in stage. This shows what this crossroads is all about. All states and all persons under the jurisdiction of this court would benefit from having a clear interpretation, elaborating on the sense and scope of state obligations that is also in keeping with other advisory opinions, so as to avoid contradictions and distortions in a topic that calls for joint efforts by all. Thank you, Madam President.
Thank you to the representatives of the United Mexican States. We will now recognize the representatives of the Republic of Vanuatu.
Members of the court, it is an honor to appear before you in these proceedings on behalf of the Republic of Vanuatu. With your permission, we would first like to show a recorded speech by Vanuatu's Minister of Climate Change, the Honorable Minister Ralph Rickenvanu, and I have been instructed to deliver the second part of Vanuatu's oral submissions, which will focus on a few key legal questions. We would be grateful if you could now play this video. Go ahead.
Es un video. Pero lo que tiene es la oportunidad de que en su tiempo hiciera lo que quisiera. Mientras esté dentro de su tiempo.
Distinguished members of the court, the situation will have many
salga antes que la nuestra.
No, ya hay fecha, el 21 de mayo lo van a sacar, o sea ya. Y cuando estemos en Brasilia. Mira, ahí está la amiga de Humberto, la de la peluquita, ¿la ves? La Mónica. Está ahí atrás.
Madam President, distinguished members of the court, the situation of many states within the Inter-American regional system, particularly small island developing states, is similar to that of the Republic of Vanuatu. Many states all over the world whose existence is on the line are particularly vulnerable to the adverse effects of climate change that they have not contributed to cause. It is for this reason that my country welcomes the opportunity to make this submission in its present proceedings before the Inter-American Court of Human Rights. The position of Vanuatu in these proceedings is that the obligations of states arising from human rights govern the conduct responsible for climate change, that is, emissions of greenhouse gases. And when a state has emitted substantial amounts of greenhouse gases, it is in breach of its human rights obligations under international law. The expression loss and damage, recognized in Article 8 of the Paris Agreement, is synonymous with a massive impairment of human rights. In its submission, Vanuatu addresses, more specifically, the following two questions put to the Inter-American Court. First, question A2B, concerning the principles that should inspire the actions of mitigation, adaptation, and response to the losses and damage resulting from the climate emergency in the affected communities, and, particularly, the loss and damage component of this question. Second, question F2, concerning how should states act, both individually and collectively, to guarantee the right to redress for the damage caused by their acts and omissions in relation to the climate emergency, taking into account considerations of equity, justice, and sustainability. Council for Vanuatu will address these questions in its oral submissions. For my part, I will limit my brief introductory remarks to three main points. The first point concerns the understanding of loss and damage as synonymous with human rights violations at a massive scale. Loss and damage is recognized in Article 8 of Paris Agreement as having already occurred. In this provision, the parties recognize the importance of averting, minimizing, and addressing loss and damage associated with the adverse effects of climate change, including extreme weather events and slow onset events, and the role of sustainable development in reducing the risk of loss and damage. Yet loss and damage cannot be understood truly unless a human face is added. In the everyday life of the indigenous people of Vanuatu, who are known as Ni Vanuatu, much like other peoples at the forefront of loss and damage, the widespread adverse impacts and related loss and damages to nature and people have a very concrete meaning. For example, one fellow citizen quoted in our written submission says, "I am more concerned about sea level rise, which is washing away our land, which our forefathers have inherited over many generations." Another fellow citizen from the island of Ambram explained that the destruction of yam, a traditional root crop and staple food in Vanuatu, due to increased climate variability, not only involves physical losses, but also leads to a loss of rituals, rites, and customs of the yam, violating Vanuatu's social fabric, culture and traditions, identities, and food security. These and other impacts of climate change on the Ni Vanuatu's human rights are producing cascading implications on numerous other interconnected human rights and can transcend across generations. My second point is that loss and damage is not only synonymous with human rights violations on a massive scale, it is also the embodiment of climate injustice. In its latest synthesis report, published in 2023, the IPCC, Intergovernmental Panel on Climate Change, captures the essence of climate injustice as follows. Vulnerable communities who have historically contributed the least to current climate change are disproportionately affected by such widespread adverse impacts and related loss and damages to nature and people. We are being massively affected in our human rights by a problem we have not caused. The cause is, however, widely known. In relation to loss and damage, such cause is a specific conduct which includes, without limitation, A, conduct, acts and emissions that has resulted over time in significant harm to the climate system, B, conduct involving responses or a failure to respond to the adverse effects of climate change and which exposes individuals and peoples to violations of their human rights, including in the context of displacement, and C, conduct, acts and emissions resulting in a lack of redress for human rights violations concerned with loss and damage. This conduct has been displayed by specific states and groups of states over a long period of time, and it is extremely concerning that it continues to this very day unabated. My third point is that this conduct necessarily triggers legal consequences. As is well known, the legal consequences flowing from an internationally wrongful act consist of cessation of the wrongful conduct and full reparation, including through concrete measures to restore the human rights of victims. This court could make an invaluable contribution to climate justice by fleshing out the duty to make full reparations for loss and damage and related human rights violations. In closing, the Republic of Vanuatu urges this honourable court to recognise that loss and damage resulting from climate change represents a massive violation of human rights. The conduct of certain states, both historically and presently, in contributing to climate change and failing to respond to its devastating impacts, triggers clear legal consequences under international law. We place our hope and trust in this court to uphold well-established international law and deliver justice to communities like ours in Vanuatu and other climate vulnerable states worldwide, whose very existence hangs in the balance. Thank you for your attention.
Quisiera saber si han terminado su intervención.
Does this complete your intervention, or would you like to use the rest of your time? Please proceed.
Madam President, distinguished members of the court, as the Honourable Minister Regevanu has compellingly articulated, loss and damage from climate change represents a massive violation of human rights, embodying the profound injustice at the heart of the climate crisis. Building upon these crucial points, I will focus my presentation on the legal implications of this reality, addressing questions A to B, especially its loss and damage component, and F2, which concerns redress for loss and damage. I will elaborate on three main points. First, the acts and omissions of certain states have caused and continue to exacerbate the catastrophic loss and damage disproportionately impacting climate vulnerable peoples, engaging the responsibility of those states under international law. Second, these internationally wrongful acts carry clear legal consequences under the law of state responsibility. Third, a comprehensive range of remedial measures is essential to meaningfully address the human rights violations associated with loss and damage. Madam President, esteemed members of the court, as a minister noted, the conduct responsible for loss and damage can be attributed to specific states and triggers legal consequences. In this regard, Vanuatu submits that the acts and omissions of states that have caused loss and damage represent a breach consisting of a composite act under the law of state responsibility. As detailed in Article 15 of the International Law Commission's Articles on State Responsibility, a composite act refers to a series of actions or omissions defined in aggregate as wrongful. In the context of climate change, while each contributing act or omission may not itself breach an obligation, the cumulative conduct reaching the threshold of causing significant harm to the climate system represents a breach. This reflects the reality that climate change or climate damage is the product of the combined acts of multiple states over decades or centuries. This conduct over time represents breaches of international human rights obligations of the gravest order. States have duties under treaties and customary international law to refrain from actions that interfere with the enjoyment of human rights and to take positive steps to protect those rights from foreseeable harms, including from climate change. By fueling a crisis that is costing human lives, degrading vast ecosystems, separating indigenous peoples from their lands and traditions, and violating the very self-determination of peoples worldwide, states have contravened the most basic rights enshrined in the American Convention, the International Covenants, the UN Charter, and other fundamental instruments. For responsible states, this composite breach extends back to the onset of industrialization and the earliest scientific understanding of climate risks. Each day of continued excessive emissions and failing to protect rights compounds the breach and heightens the legal consequences. Madam President, distinguished members of the court, your authoritative guidance is essential for ensuring that these legal consequences arise not just in law, but as actual redress for victims. As this court recognized in Inhabitants of La Oroya versus Peru, redressing violations of the right to a healthy environment requires a range of reparative measures. So too is a comprehensive approach essential to meaningfully address loss and damage in accordance with human rights. Regarding cessation, Vanuatu submits that this entails, inter alia, legislative and other measures to rapidly and equitably phase out fossil fuels, to facilitate universal access to clean energy and adaptation resources, and to protect the rights of climate-displaced persons. Crucially, cessation also involves restoring the rights of indigenous and tribal peoples to their territories and resources. Guarantees of non-repetition must include formal recognition in perpetuity of the sovereignty, statehood, territory, and maritime spaces of climate-vulnerable peoples and states. Criminalization of ecocide and a ban on speculative, dangerous geoengineering technologies are also appropriate measures of non-repetition. Restitution, as the primary form of reparation, must comprise rights-based measures to restore fragile ecosystems and livelihoods. Compensation must encompass both economic damages and non-economic losses, such as cultural and spiritual harms, all aimed at enabling victims to continue their project of life. Satisfaction must include acknowledgements of responsibility, formal apologies, and truth-seeking processes into the anthropogenic factors that have led to loss and damage. Vanuatu further stresses the procedural dimension of effective remedies. Climate-vulnerable communities must have accessible avenues to pursue redress and to shape the decisions that impact their fates. The establishment of a new loss and damage fund at the UN Climate Conference in 2022 marked progress, but it falls woefully short of facilitating actual redress. We respectfully submit that this is the moment for your esteemed court to clarify states' human rights obligations, to robustly support such funds, and open doors to additional remedial mechanisms at the domestic, regional, and international levels. In closing, Vanuatu respectfully calls upon this honorable court to acknowledge that loss and damage violates human rights at a massive scale, affirm that such violations trigger legal consequences under the international law of state responsibility, and specify the comprehensive legal consequences that flow from these findings for all members of the inter-American system and the international community as a whole. The people of Vanuatu and vulnerable peoples worldwide look to this court as a beacon of hope for climate justice. Your forthcoming opinion could not be more vital or timely. Madam President, distinguished members of the court, thank you for your kind attention.
Thank you very much to the Republic of Vanuatu for your presentation. And now we have the question-answer session from our judges. I now ask Judge Patricia Perez Goldberg, would you like to ask a question? Yes, Madam President. Go ahead. First of all, I would like to thank everyone for the submissions we have heard this morning. I do have several questions, but in lieu of time, I will only be proposing some. So first of all, a question to the representatives of the state of Chile. During your submission, you have referred to the framework law on climate change that was recently adopted. I would like to hear some thoughts on the impacts of this law and in particular the management mechanism it establishes. Thank you very much, Madam Judge, for your question. We are also grateful to have the opportunity to come here and speak on Chile's experience. In 2022, Chile promoted an act on climate change. It's a law, as we heard from our ambassador, that establishes a series of provisions, the most important of which is to reach a peak of emissions and then start a gradual decrease of GHG emissions until we stabilize and maintain emissions to carbon neutral by 2050. This might seem like good news, but additionally there are other very relevant elements. First of all, a series of principles are set forth that bring to our domestic legislation all the principles we have heard about that are coming from international law within the general environmental area, but also for climate change specifically. So what we do is provide a legal relation to the international law principles. And they are also provided with a legally binding nature in terms of other elements, such as obligations as such or international commitments, such as updating and creating the nationally determined contributions and preparing climate adaptation plans. And these are not just national adaptation plans, but we also have sectoral adaptation plans for different industries, such as fisheries and agriculture, in terms of biodiversity, cities and climate change. And all this is relevant to ensure it is not just culturally relevant, but also geographically. Another element is that we recognize different management instruments to face climate change, not just at national level, but at local level as well. As you have pointed out, Madam Judge, this law was passed in 2022. It is currently being implemented under the Ministry of Environment in Chile, and it is establishing a series of regulations to ensure we can fully enforce this law soon. We have different deadlines and terms within the law, so it's not diffuse, it's not vague. We do have specific time frames, and we should have these coming into effect soon. This new law not just recognizes a series of regulatory or management mechanisms, but it also acknowledges the need to establish a series of financial instruments to face climate change. In the understanding, as we also heard from the distinguished delegation of Barbados, that facing climate change is not just a matter of having procedural obligations, we should also take charge on the financial aspect of it. So these financial instruments acknowledge the main duty of a state to protect the population within its territory, so they are fully responsible, first of all, for this. But these financial instruments also provide a possibility of looking for other sources of funding beyond the national. And another very important element that is closely linked to the advisory opinion provided by this court in 2017 on the duty to prevent and the guarantees to provide information, this framework law on climate change acknowledges the need to establish instruments to provide information on climate change. This is absolutely important also to consider decision-making in public policy based on the best available scientific evidence. And this, again, provides geographic relevance. So for that, we also have instruments to provide baseline information so that we locally establish the specific needs of our country and its regions in terms of mitigation and adaptation to climate change. Also along the lines of the Paris Agreement under Article 7, Paragraph 5, that refers to the need of counter-specific measures. I hope I answered your question. Thank you. A second question now for the speakers of Colombia and Mexico. You have both referred to the need of adopting differentiated measures with respect to vulnerable groups in conditions of structural inequality. Based on your concerns, I would like to ask, from the point of view of good practices of different states, are there any mechanisms for participation, which of course is a very important element in terms of climate action? Any elements that help us know what are the needs of these vulnerable groups to construct public policy in the matter? Yes, thank you, Madam Judge. I will give the floor to Juan Sebastián. But first, I would like to say that the National Development Plan that I referred to as a mechanism to address the climate crisis is a plan that for the first time in history is being openly discussed with communities. And we had hundreds of thousands of people participating. And I remember that in this particular case, we had more than 300,000 people participating in several regions of the country from the different affected areas. Thank you, Honorable Judge. Yes, Colombia does guarantee the right to participate following all the consultation process elements established by the ILO, and we do not just have the need to consult communities, we need to ensure there is consensus with them. In Colombian jurisprudence, we have established that natural resource management should not just consult the communities that depend on these ecosystems, but others. And then our jurisprudence has recognized the abstract nature, the fact that the rights of nature are closely linked to the communities that live within that nature. In the context of the visit to the Inter-American Commission last week, we visited the Department of Chocó in Colombia, and the communities were very proud to have the judgment of the court that recognized their rights, not so much for the ecosystem itself, but also for them as representatives of the environment in that community. And that is just one of the ways Colombia has come closer to ensuring environmental participation. Thank you very much. And if I may, for Mexico as well. Thank you, Madam Judge, for your question. I'd just like to point out 3 laws that we have in Mexico that are applicable to your question. First, the general law on the rights of children and adolescents. Second, a general law on access of women to a life free from violence. And these 2 are related to the one I've already mentioned during my speech, which is the general law on climate change, which includes the obligation of a state to provide consultation to these specific groups. And to add to that, the Escazú Agreement that I mentioned was ratified by Mexico includes these obligations for the state of Mexico as well. Thank you very much. And lastly, a question on the presentation by Barbados. You referred very interestingly to the obligation of preventing cross-border damage. This court has already issued an advisory opinion on this, on the environment, advisory opinion number 23. Do you have any thoughts as to how we could improve enforcement of that obligation, ensure compliance of it, whether within the framework of the Paris Agreement or in other contexts where you have already analyzed this, in the understanding that, of course, it is a central element, not just to ensure compliance of nationally determined contributions, but also in how we will address this problem globally. Thank you.
Thank you, Madam Judge. That is not only an excellent question, but perhaps the question for the day and for the hearing. And I wish that Barbados had magic answers. It is a challenging question, how to ensure compliance, and it is a central element. One of the challenges facing this court and other courts dealing with the issue is the reality of the differentiated capabilities of states to respond to climate change, both in terms of adapting, ameliorating, and so on. One approach is to accept the general principle of obligation, but then vary the application according to capacity. The problem with that approach, or at least that approach only, is that in fact what you are doing is you would be creating strata of compliance to a human rights norm, which is, I would humbly suggest on the part of Barbados, a dangerous thing. So if that's the only approach taken, that would be worrying to Barbados. But there is the reality of the differentiated physical and fiscal space amongst countries. Financial contributions are one way to address this. Another way to address this is to look and take examples from other areas of public international law, for example, trade law, investment treaties, and look at how states can and do adjust variations in capacity, fiscal capacity, economic capacity, fiscal space, economic space, and how they adapt not the obligations per se, but the ability to fulfill them and the economic financial adjustments required for that to happen. So, for example, you have the system of general preferences, WTO, GATT, etc. There are ways to do this. And as one of the points that was raised by the agent of Barbados that is of extraordinarily significant concern to the countries of the Caribbean, and indeed probably all small island developing states, is the reality of the receding nature of insurance coverage, which at first glance sounds like it has no connection with human rights or development issues or whatever. But the reality is that countries in which it is not possible to get insurance, it is not possible to have realistic, advanced economic progression, because economic activity in the modern context, even for centuries, has required elements of insurance. And particularly for foreign investors to come into states with less physical and fiscal capacity, particularly small island states, there requires on the practical level to be insurance coverage for these investments. And obligations on international institutions such as the Inter-American Bank to do things required to ensure access to insurance would be ways that would not require specific numbers to be attached for money to be sent from one place to another in terms of this sort of compensation concept, but would put obligations on international financial institutions, and therefore, by virtue of how those international financial institutions themselves get money, on more developed states, to provide a very, very meaningful economic contribution, which would be insurance guarantees or access to insurance guarantees, which can operate on a commercial basis that wouldn't put too much onerous obligations on countries, because it's well known the world is facing enormous crises that are draining the public funds from developed states. So these would be the sort of things that Barbados would very much like to see, that Barbados thinks other small island developing states would like to see, mindful, as my colleague Mr. Sharma said, that the reality of the Kyoto Protocol, the Paris Accords, and so on is, as we all know from reading them, there's no hard obligations contained in them. And so to shift the obligation onto those very useful steps along the way, but thinking that they can, as legal instruments, accomplish something which their texts do not allow and which at least major parties to them say they do not uphold, would be too much than they could bear. So Barbados recognizes that the Inter-American Court is part of the Inter-American system and part of the OAS, and the focus, therefore, is on the Inter-American system and the OAS system. The Inter-American Development Bank is a wonderful example of an institution that is obliged to take heed of this court's rulings and effect those rulings in its operations. And that would be one very meaningful way in Barbados' submissions for the court to accomplish the central element of financial contribution in relation to not just the projects to require that money could go in, but ensuring access to insurance, particularly industrial commercial insurance. Thank you very much, Madam Judge, for the opportunity to respond for Barbados.
Thank you very much. No more questions, Madam President.
La jueza Pérez Goldberg pregunta.
Thank you, Judge Perez Goldberg. Judge Veronica Gomez. Yes, ma'am. Thank you. First of all, I would like to acknowledge the submission of this request for a advisory opinion by the states of Chile and Colombia in the best inter-American tradition of the late 19th century of fostering the development of international law and international relations, peace, and human rights, which has been characteristic of the states of the region. And I think that this request has been submitted in the best tradition of the Organization of American States, the region, and in the interest of development of international law and instruments. I think that must be underscored. We have listened closely to the domestic measures, to the policies, with the hope and the hopes that those be state policies and not just the policies of a certain administration in regard to that specific topic. And I see the reactions around the room in that regard, and with very good examples provided by Mexico as well. So this is a question that will crop up over the next 3 days, I'm certain. I would also like to acknowledge the presence of the state of Vanuatu. Thank you for taking part in these proceedings. We attach a great deal of importance to your presence here. I have only 2 questions. First, for Mexico. It's about the closing ideas submitted by Mexico about dialogue between international courts. Mexico referred to the need for a dialogue. It referred to the imminent decision by the Tribunal on the Law of the Sea and also the proceedings before the International Court of Justice, where Vanuatu is very much an engaged participant, and also made a request, and that is Mexico, about the dialogue between international courts about a very important, globally important issue. Everything having to do with human rights is, of course, such, but this has other specifics. So international courts were created by the states, by the international community. So how can an international state, a state such as Mexico, propose that there be contact between the courts around a topic such as this one. Thank you, Judge Veronica Gomez. The proposal put forth by Mexico is due to the importance of this issue for all of humankind. As you said yourself, all three major international courts are currently working on this issue under the modality of an advisory opinion, and each is doing so under its jurisdiction. The Tribunal of the Law of the Sea, based on the sea, the International Court of Justice about obligations and general responsibilities by the states, and the Inter-American Court with a human rights approach for the region. So following from that, it would be very important for there to be a dialogue of that nature so that the three advisory opinions to be handed down be supplementary and coordinated so as to maximize the impact, the effects on the issue of climate change as a problem. But how do we go about doing that? Well, there's the proposal, and I would expect the courts to be able to speak to each other in view of the importance of the matter. As you know, there is a regular dialogue that is organized with the other regional human rights courts, but it's informal and it doesn't have an impact on our case law. It's not a matter of coordinating our work. What a state of the international community is proposing is that there be this other type of dialogue for coordination of our work, which is completely different from anything done in the past. Is that what you're requesting? This type of dialogue, a dialogue of coordination or just contact? What are you proposing? I believe that the point of departure might be an informal dialogue for each of the courts to share their experiences in these hearings and these for advisory opinions. But we do not have an answer as to what the exact method would be. We believe that the issue of climate change warrants some innovation in this regard. So a way should be sought for contact to be had between all three courts, either formally or informally. Thank you. My second and final question is for Barbados, so I'll switch to English.
Volterra, again, same topic. Sorry about that. You spoke about interstate compensation informed by customary law, and that should be one of the issues addressed by the court in its advisory opinion. You even said, if not, the advisory opinion would be a rich person's advisory opinion. Those were your words. But then we heard lots of arguments about international responsibility, also brought by Vanuatu, very clear terms, that refer to, the classic way of having a look at damage, international wrongful acts, and reparations. And Vanuatu was very, very honest in the way in which you expressed that we're talking about damage that is connected with the onset of industrialization and the first understanding of climate damage. Have all of these issues. Are the paradigms, the classic paradigms of state responsibility, with all the ingredients that you mentioned, of course, about environmental law, applicable to a situation like this? Do we need new paradigms? It's very interesting, all that we've heard also about insurance. But we're still talking about insurance with the parameters of the 20th century, the 19th century, the 18th century, the 17th century. Are the paradigms that we're trying to work with the ones that are going to help us understand how we address this particular type of damage? Thank you.
Thank you very much, Judge Gomez. Again, it's very impressive to note from the questions how the court has been following all of the pleadings carefully, both written and oral. And not surprising at all, but very encouraging for all of us here today and the people watching around the world to see this engagement. So thank you very much. Barbados's view is that we do not, as Barbados, as members of the Organization of American States, as parties to the states parties to the inter-American system, we do not need to create new laws. If by paradigm the court were to mean new ways of conceiving the application of existing laws in relation to new facts, then Barbados would endorse and encourage that, and indeed has in its submissions said as much. If by new paradigms is meant that what the inter-American system requires is an entirely new set of legal tools that are not currently available to this court, to the participants in the inter-American system, Barbados would not agree with that. Barbados's view is that the toolbox of law is there for the court, for the world. The toolbox of customary international law is there. Of course, time was short today. I couldn't cover everything, but the reference to the customary international law of transboundary harm and so on, that is a tool available to this court. The court traditionally imports the corpus of customary international law to inform the interpretation of the convention, and rightly so. And the tools are there for this court to apply them, to apply the existing tools to a very complex and rapidly evolving and uncertain timing in terms of proximity of events, whether the climate catastrophe will happen tomorrow, whether it's already happening, whether it will happen in 5 years, but certainty that it is happening and will happen in relative terms very soon. The toolbox is there to create the systems, responses that are appropriate to give structure and guidance in binding legal terms for the construction of the outcomes. Because Barbados recognizes that the reality of climate change being global and the differences in fiscal and physical space amongst states means that the court would not necessarily be serving the world or the peoples of the Americas if it was to create a new set of legal norms and rules out of nothing that would then get
That's
forced
clear.
on.
Sorry
Yeah.
that I interrupt you because we have very
No,
little time. Sorry,
you.
one quick follow-up question. You mentioned specifically the IDB, the Inter-American Development Bank, but at the same time we're talking about the impact of polluters, of states that have more emissions because of their development. They're not all necessarily in this region. So how do we understand what sort of message the court should give in terms of the nature of the damage that we're talking about and the transboundary nature that is not only my next door neighbor, somebody that is on the other side of the world as well. So why the focus on the OAS and the IDB that don't have such a direct relationship as you're suggesting, they're really separate institutions. But why that focus only?
Well, thank you for the opportunity to address that. Mindful of the time, I will be quick. I think it's very clear Barbados's position is that the problem is global. The measures needed to address the problem are global, but the inter-American system is what it is, and it has a it has a geographic focus that is inarguable. This does not mean that the court cannot make pronunciations and identifications of law in customary international law that are applicable within the inter-American system. Of course, the court can and does and has recently, even a few months ago, and Barbados encourages the court to do that. Barbados thinks that it's for the court, that the court's recognition of the global aspect of the problem and the solution requiring global responses does not mean that the court cannot do what is required in terms of establishing and identifying and recognizing legal norms within the inter-American system. It then is for others to take those globally. It is then for the member states of the OAS in other fora, recognizing the global nature of it, to take the norms and rules that this court can identify and reference them globally. Is that a sufficient answer?
Okay, thank you. No more questions, please.
Muchas gracias a la jueza Verónica Gómez. Que si desea hacer preguntas, adelante, don Ricardo.
Sí, señora presidenta. También quiero preguntarle algo a Barbados en función de...
I would also like to talk to the representative of Barbados about the answer he just gave. You have insisted or reiterated the jus cogent nature of the obligation to redress. I would be very interested in hearing you go into this in more depth. I would like to hear further arguments along the lines of why these provisions are jus cogens and what is the scope and what are the consequences thereof concerning what this court is currently considering in this request for an advisory opinion.
Thank you, Your Honor. If I may answer for Barbados. As Barbados has set out in its written observations, the dual doctrines at issue, which are A, the obligation of states not to harm the environment of other states, the transboundary harm principle, and B, second, the related obligations on a strict liability basis to compensate for harm done on a transboundary basis, are ancient. So in respect of your question is why are they jus cogens, it's twofold. One, they are established for centuries, indeed for thousands of years. It is a Roman principle of law, sic terre, and although it was not briefed in these submissions, other legal traditions around the world, predating the Romans, from that Code of Hammurabi to the Sanskritic Manusmriti in India, to Sharia law, as established by the Prophet Muhammad, peace be upon him, encompass the same two obligations, identically. So it is an ancient principle which assists in its identification as a peremptory norm. And it is also, as we see in this proceeding, one of grave consequence to all states and their populations. Because we have seen from the mere fact of the climate crises that the violation of the established transboundary harm principle and the failure to ameliorate and compensate for the same causes global impacts with great distress on all human beings. So our submission is, in short, it is a jus cogens peremptory norm because it is ancient and established among nations and because it has grave consequences on human populations.
What would be the role, if these are in fact principles of jus cogens, what would be the expectations? What do you hope for from this advisory opinion with respect to the application of these general principles?
I think I would reiterate the observations of Professor Volterra. Of course, if you establish the principles as jus cogens or merely customary international law, the impact is the same on the states. It is still an obligation of the states. Having defined that obligation in express terms, this court will allow states to understand the legal framework on which they must approach climate change. And that will aid in all sorts of areas. It will aid in negotiations between states as to the correct amount and form of reparations. It will assist international institutions, including those of the Americas, especially for this court, in crafting their policies in light of states' obligations as they have been defined by this court. The current system, the current way, does not work because states do not know through judicial pronouncement precisely the obligations that apply to them in climate change. And so there are some states who deny their obligation to compensate or the relevance of the transboundary harm principle. By defining the principle, the court will help guide diplomacy, negotiation, and future judicial decisions.
Thank you. I have another question for Barbados. You have made reference in your oral submission to the declaration on the Bridgetown Consensus. So my question is this: how does this initiative, the Bridgetown Consensus, how would it tend to provide avenues for solution or for complying with the obligation to redress?
Thank you very much, Judge Perez Marica, for your question. Again, very good questions. These go to the heart of the issues. The Bridgetown Initiative, the Bridgetown Accords, are attempts by Barbados to provide some global leadership for like-minded countries, addressing exactly what Mr. Sharma just said in relation to your previous question. And that is to say, they're an attempt to coalesce understandings of states around the normative obligations in international law. You saw what came out of the last COPs, this fund. It's a voluntary fund. There's been rhetoric around it, but nothing more. Because, as Mr. Sharma pointed out, there are some states that say, well, there are no legal norms. There are no obligations on this point. This is something entirely new, they say. We have to look at Kyoto Protocol, Paris Accord. There's nothing there. Barbados' position is that this is legally incorrect. The rules, the norms do exist. The toolbox is there. And the Bridgetown Accord, the Bridgetown Initiative, would fit harmoniously with the sort of outcomes in an advisory opinion that Barbados and many of the states making submissions this morning would say is entirely appropriate. Identifying these norms, saying that there are laws that are applicable. They existed in the past. This isn't some fictitious creation of equitable readjustment of economic space. That this court would be following orthodox international law, and identifying it will be of enormous use, just like the Bridgetown Accord was trying to do. Thank you very much.
Thank you very much, Barbados. I would like to go back to, I have a question for Vanuatu. First of all, Vanuatu has come before this request for an advisory opinion and has also done so with the International Court. And we would like to know how you connect the work that is being done by the International Court of Justice with the work being done now by ourselves, faced with this request for an advisory opinion.
Your Honor, thank you. Thank you very much for giving us the opportunity to elaborate on this critical question about the connections between these different proceedings. So let me put it in the simplest terms. It is Vanuatu's hope that this court will provide an opinion that can serve as a stepping stone for the opinion that will be issued by the International Court of Justice. Of course, in both proceedings, different questions have been asked. They're not identical. And of course, each institution has its own membership and has its own particular law that it applies, etc. But there is importantly significant, substantial overlap in the questions that are before these bodies, and it's no coincidence because these are really the questions that are at the heart of what is at stake from a human rights perspective and from a justice perspective, and when it comes to the climate crisis. And Vanuatu submissions have been Vanuatu submissions to your court have been made with a view to suggesting ways in which the Inter-American Court can grapple with some of the legal questions that also arise in the proceedings before the International Court of Justice in a way that will assist the International Court of Justice in clarifying certain aspects. And one, of course, we could elaborate on the exact questions and potential areas of synergies for hours, but to keep it brief, in Vanuatu's view, the key area where the Inter-American Court can assist the ICJ in grappling with the questions that are before the ICJ is the area of reparations. And that's also why Vanuatu, like Barbados, has focused its submissions very much on question F. And we would also agree that question F encompasses the other questions because we are addressing questions of legal consequences and breaches. So to understand a breach of positive obligations, for example, you need to understand the content of those obligations, also to understand what cessation entails, for example. And it is this court's very rich jurisprudence on reparations, including on reparations for harm suffered by indigenous peoples and tribal peoples, that is incredibly relevant to the broader question of reparations for loss and damage. And so there's a very distinct and important role for this court to provide this authoritative guidance, which then also can help ensure that the obligations that have been articulated, which are of course for a large part derived from not just the American Convention, but also the ICCPR, ICSCR, customary international law, many other instruments with a broader or even global scope, to ensure that the interpretation of the court also gains, in a way, a global effect. Does that answer your question?
Thank you very much. Thank you much. Yes, you were very explicit, very clear. I would simply ask very specifically, there is something that concerns me. You have said concerning in your observations, in your submissions, paragraph 26, that the conduct for contributing to the threshold after which emissions cause substantial damage to the climate system or other components of the environment. So, what would be the standards for defining a threshold? The threshold of significant change that you would like us to include in the advisory opinion?
Thank you, Your Honor. And that's a critical question, of course. So Vanuatu is suggesting to articulate a threshold of significant harm, to causing significant harm to the climate system and other parts of the environment. And here, of course, we are all aware that this particular formulation also features in UN General Assembly Resolution 77-276, which requests the advisory opinion from the International Court of Justice. This threshold of significant harm is, of course, rooted in the principle of prevention and the duty of due diligence on the customary international law. It is a standard that must be applied contextually with due regard for the circumstances present in the state, in a responsible state, to determine whether what the standard exactly entails, and so also when it has been breached. And it is also a standard that must be applied with due regard to the nature of the harm. And here we suggest that it is essential to ensure that international law here is applied holistically, because applying the standard in isolation could dilute what states' obligations under international human rights law, for example. So when we look at significant harm, the nature of harm, it's important to recognize that harm in this case entails violations of human rights, including the right to self-determination, which in Vanuatu submission is a jus cogens norm, as well as right to life, health, food, etc., the right to a healthy environment. So it is in this holistic way that in Vanuatu submission, this standard must be understood, articulated, and applied. Does that answer your question?
Yes, thank you very much. I have no further questions, Madam.
Thank you, Judge Perez Manrique. I now ask Judge Eduardo Ferrer Madregor. Will you ask questions? Yes, Madam President, thank you. First of all, I would like to echo the words expressed by my colleague, Judge Veronica Gomez, to thank the countries requesting this very important advisory opinion that brings us here today. So to Chile and Colombia, thank you very much for following this tradition, which I believe is very important within the Inter-American system and can help us open dialogues that I hope will be productive for our objective. And the general goal that we are all thinking about, which is fighting the negative effects of the climate emergency. Having said this, I wish to thank the rest of the countries who are present today and those who will not be giving their submissions today, but will participate either later on this week or in Brasilia and Manaus. And I will be specific in my questions. Some of the speakers mentioned, for example, Colombia, and also in its written submissions, the right to nature, or the rights of nature. And Mexico specifically referred to highlighting the importance of knowledge that indigenous women and children have and how they're closely linked to nature, the land, the territory. So I'd like to ask the representative of the United Mexican States, how could this knowledge that you have referred to, these local traditional knowledge, along with the best available scientific knowledge to determine shared but differentiated liability of states. This entails to determine the obligations in terms of mitigation, but differentiated. So the first question is whether it entails common but differentiated obligations. Thank you, Judge Ferrer MacGregor, for the question. To answer very specifically how we can connect the knowledge that indigenous women have and the best available scientific evidence, the fact that states have the possibility of consulting or the obligation of consulting these women and children. There's also the obligation to take into consideration such information for decision making at the state level. And something else I did not highlight in my submission, but is very relevant, is that we currently have the third Conference of States Parties to the Escazú Agreement, and they are contemplating some aspects related to gender in terms of protecting human rights defenders, and especially linked to the environment. So again, with the idea that any consultation done with indigenous groups would be the best way to ensure their knowledge is included in decision making. Colombia, would you like to add something? Yes, thank you, Judge. As to the rights of nature, we all know that Colombia has been a leader in jurisprudence in this sense, and international law that is current in effect in recognizing nature, and always to ensure the public policy of the state can be applied and that it has a voice of the communities. This is following the Global South's traditions started by India, where the National Great Tribunal and the Supreme Court of India were the first to recognize the rights of animals and nature. And based on that, with the different judgments and structural judgments, our own judges, following leadership by the Inter-American Court of Human Rights, have also applied control of the aspects of environment included in the convention. We did it with the Amazon River judgment that directly refers to the Paris Agreement on climate change and establishes that future generations, children that will live in these communities and depend on these ecosystems, have a voice and are represented and that can also speak for nature as such. Considering the rights of nature is fundamental, as it allows us to provide a voice to those who are not yet represented in current democratic debates. Obviously, children, future generations, they cannot vote in our democratic systems, and so judges have assumed that role of ensuring they have a voice. This guarantees that we are close to communities and that decisions are relevant to people who will be affected by them. In Colombia, we have the case of Atrato, Gotún, and Amazon rivers, several ecosystems of our highlands as well, and to the point that judges have actually said that some administrative authorities are in contempt as they have not applied the measures to protect these areas. So a judge can issue a judgment with certain orders, and then you also have monitoring to ensure these standards that are included in the judgment are applied and enforced. And this is what helps us effectively prove or see that our administrative authorities are applying international standards. And that's why the delegation of Colombia considers it important to insist on the environmental aspects of control of the elements in the American Convention. This happens through you, international judges, coming down to our national domestic judges, who are the ones spearheading international law in our country. I hope I answered the question. Thank you. Since you are already answering, recently, in just some past days, the Constitutional Court of Colombia has issued a judgment on the need to provide greater protection to those internally displaced by climate change. Could you refer to this, please? Yes, thank you, Your Honor. The Constitutional Court of Colombia found that although we have robust legislation that allows to include measures that protect populations that are part of forced displacement and this type of movement, these measures are insufficient to truly protect these populations when the reason that has led them to move, in this case it was a couple of farmers that had to move from the riverside where they lived, they are insufficient to truly address them when the specific causes of this displacement, this internally forced displacement, refer to environmental aspects, in this case due to the consequences of climate change. So what the Constitutional Court requires is to adapt any measures that already exist to ensure urgent protection. It could be temporary and limited in time, but it is urgent to specifically address the causes that led to that internally forced displacement. So legislators are forced to adjust what we already have. Thank you very much. And in general terms, on several occasions we have heard the term mitigation. And in the written observations, there's also reference to the principle of the maximum ambition possible. What criteria should be used to inform internal analysis regarding this most or maximum ambition in terms of mitigation? What does that mean? First of all, what do you consider the court could determine in that respect as to the meaning of this maxim in the context of the climate emergency? How can a court determine whether a country is following or truly applying the maximum possible? I'm not sure if Chile or any other state, if you would like to intervene. Thank you very much, Judge. It is particularly relevant to ask this, especially if we refer to mitigation. As a region, we are one of the regions that least contributes to the number of global emissions, and we are one of the most affected. We're highly vulnerable to climate change. So the question of mitigation is particularly relevant if you try to see how our region can help mitigation, if again our region is not necessarily part of the large emitters globally. So if you think about the climate change regime, there are several mechanisms established in Article 6 of the Paris Agreement that set forth a series of mechanisms that we can call feedback mechanisms, put in the simplest of terms, which would allow to establish a relationship between our region and other countries that are large emitters, so that we can allow for several mechanisms in Article 6's market or non-market mechanisms to ensure we create mitigation mechanisms. So that's the one thing. Then I'll refer to the second part of your question as to the ambition. Under that viewpoint, the states of the region have particular ecosystem conditions that allow us a large amount of absorption of CO2 and other GHG gases based on carbon sinks that we have in the region, mangroves, the Amazon region, the oceans. our marine seagrass, the algae forests. So we have several possibilities in our region to become carbon sinks that could be protected or should be protected. And one of the mechanisms that allows for this is the voluntary mechanisms, the market and non-market mechanisms under Article 6. And since we had this question before of the distinguished delegations of Mexico and Colombia, not just information. Another important way to incorporate local communities in these mechanisms is providing management of these types of tools at community level. So indigenous peoples could take charge of this. For example, the Paris Agreement itself, under one of the mechanisms, included to ensure development, capacity buildment. It creates the Plus network, our Plus network, and then part of its safeguards includes social and environmental safeguards, particularly the protection of indigenous peoples and local communities, as well as their participation, both in managing and benefiting from applying these types of mechanisms. So as we heard from Barbados in this toolkit that we already have in international law, we have these mechanisms. And now to the second part of your question. How can we ensure or measure the maximum ambition possible? And this is something that the judgment of the European Court on Human Rights very recently regarding the Swiss Confederation considers that state has not complied because they have not established minimum knowledge, like the inventory of emissions. So how do we know that the state is being as ambitious as possible without information on this? So the first step is to have information. And that information is related to the capacity of a state of issuing these emissions, but also the capacity it has in terms of carbon sinks, finding where it has carbon sinks, and based on that, finding out what measures that state could take, and applying the different mechanisms included in the Framework Convention and the Paris Agreement, as well as other international instruments, to have these mitigation activities take place. So under that viewpoint, the standards should first of all at least include baseline information. There should be baseline information to determine the state of affairs. From that standpoint, our intent is not to just provide a long list of standards, but we do believe that a starting point is to establish that baseline, the status quo. What is the baseline in terms of a capacity to extend that later on? And here, the second part, probably the most relevant to our region, if I may, is adaptation. And to determine adaptation, we also need information first. What is the territorial status? What are the threats of a state? Because only with this information will we be able to determine whether the measures taken or the actions taken by the states are ideal to fight climate change. And consequently, if these measures being adopted are actually following the most ambitious goals. Because if we do not know the national circumstances of a state, it is absolutely impossible to determine whether the state is actually being as ambitious as it could. I hope I answered your question. Yes, and this brings me back, and then with this opportunity, with the toolkit that Barbados mentioned, where they also refer to the 3 large conventions on climate change that are all complementary to each other and not restricting existing obligations. So again, a general question anyone can answer. This is the last question, if I may. There's a risk that states, by complying with the Paris Agreement, and although they may be complying it, they could be violating provisions of the American Convention. So is it insufficient to follow what is established in the Paris Agreement in light of effectively complying with human rights enshrined in the American Convention? Colombia and then Barbados. I think I saw you both. Thank you so much. Thank you for the question, Your Honor. As you know, and all of us here know about the story of how these multilateral instruments were negotiated, it has not been an easy task, and developing countries have had, and the developed countries have had very different positions from those of us who are appearing here today, because we're most affected by climate change. So in that sense, what you are saying is a possibility if those principles we have all mentioned are not enshrined in that. And coming back to your question on the most ambitious goal, what we've seen in practice is that the most ambition has not been really very ambitious, to put it simply. So it is insufficient. What has been done to date is not sufficient, even in the nationally determined contributions declared by the large issuing states or emitting states. It has not been enough to address not the crisis anymore, but the climate emergency. These negotiations have taken so long, it has taken so many years in discussions, we have not met the goals. There's been delays, and we know that they will not be complied with. So it's perfectly possible that a state may be strictly complying with the mandates of these international conventions, and specifically the Paris Agreement, but still be non-compliant in terms of international liability, because they are not fulfilling their responsibilities or obligations on human rights in the context of climate change under the American Convention. I hope I answered your question. Thank you. Your Honor, we had Barbados asking for the floor first. Thank you.
Señor Juez, pero, sorry. An excellent question. Barbados's view is that the theoretical possibility of a state that complies with the particularly Paris Accords, but those three treaties we mentioned, may somehow, by complying with it, violate the obligations it may have under the Inter-American system, is not a possibility. That is because, in Barbados's view, these agreements do not set out the universe of legal obligations to states that are parties to the Inter-American system. They may give some guidance in certain respect, but they do not create a sui generis legal regime. They do not create jus cogens norms. They are not obligations that compliance with them prevents compliance with stronger norms, stronger obligations in international law that exist. So in Barbados's view, there can be no situation whereby compliance with those three sets of norms would cause a conflict and a violation or failure to comply with the norms applicable under the Inter-American system. Thank you.
Chile? Thank you, Your Honor. Just briefly, there are two dimensions to your question that we should highlight. First, that a state such as our own, the ones that are here, may comply all their obligations under the general framework on climate change and at the same time violate human rights in the sense that the possibility our region has of influencing this emergency is quite limited. So as Chile in its written observation has focused on the obligations of adaptation for every country, including our own, adaptation also has its limits. There comes a point where a state that is compliant, strictly compliant with its obligations in terms of adaptation, will also have people affected due to the damages caused by another country. So on the one hand, a country abiding by its obligations under climate change, but also in terms of human rights, the population of that country can also be affected because of the cross-border features of the climate emergency. And on the other hand, as we've pointed out on our oral submission, there's the paradox of the climate change regime that sets forth very minimal obligations. It limits itself to the obligation of presenting the nationally determined contribution, but the agreement does not set forth how we can determine whether it is an ideal or suitable contribution. So that's a paradox. We have a regime where we all agree that we have to limit the increase in temperature, but we don't have clear criteria under which states effectively have to ensure they fulfill that commitment, beyond an obligation that is almost exclusively procedural to submit and update their NDCs. So a state can do that only, and this may not be sufficiently ambitious, as we've mentioned before. And therefore, the position of the state of Chile is that human rights standards have the potential to, on the one hand, complement this regime because human rights are not displaced because of the climate change regime. So we can add to that and provide the character and the executing capacity that it does not have in climate change, but it does exist, at least domestically, for us in human rights. In that way, at least partially, filling that gap that we have in the legal framework in terms of climate change. Thank you very much for your answers. No more questions.
Muchas gracias.
Thank you. I'd like to ask the Vice President, Rodrigo Budrovich, if he has any questions. No.
No, Madam Chair.
I would just like to thank all the states that have submitted their written observations and those who have participated. I know we have a long day ahead of us, so I wish to ask no questions. Thank you so much.
Del tiempo y aunque tengo muchísimas preguntas, solo quisiera hacerle una amable petición al Estado de Barbados. Este tema de los seguros me resulta fuera de mi área.
I'd like to ask Barbados about insurance. This is outside of my area of expertise. I know that a broad explanation about the problem that is that we're seeing has been offered, but I'd like to see something in writing with specific data about the specific problem, about the types of clauses that are used in these insurance contracts that affect what you see as affect the development of countries in your view, and the alternatives that you would be suggesting to be able to broach this problem. So, but in writing, please. In the interest of time, we couldn't do it otherwise. But I'm interested in the specific data. Reference has been made to what is happening in other countries, the economic burden that this is creating, the cost, etc. Madam President, thank you for this opportunity. On behalf of Barbados, I will take you up on this invitation, and we are going to discharge this task in the upcoming days. Thank you. Thank you so much, and we will now break until 12:15. Thank you.
De pie, por favor, la Corte se retira.
Please stand. if you're not using some of the chairs, please do not take those up with your personal effects in case other people want to join us in this room. Please free up those seats.
Señoras y señores, de pie, por favor.
Ladies and gentlemen, please stand. The court. This hearing is called to order. Next, according to the order that has agreed upon, we will hear from the Inter-American Commission of Human Rights. Madam President, you have the floor.
The Commission extends its greetings to Madam President and the honorable judges of the Inter-American Court, to the delegations of member states and all representations and individuals present in this hearing. We thank Chile and Colombia for this request for an advisory opinion on state obligations to this looming existential crisis that is climate change. In this presentation, I'm joined by Commissioner Carlos Bernal Pulido, First Vice President of the Commission, and also by the Special Rapporteur on Economic, Social, Cultural, and Environmental Rights, Javier Palomo Lantis. The Commission will concentrate on state duties of prevention and guarantee in response to the climate emergency, on procedural aspects, and on differentiated approaches, taking into account the diversity across the Americas and the Caribbean. This includes addressing the circumstances of states that are major carbon emitters, small island developing states with minimal emissions, low-lying countries, and nations with substantial carbon sequestration capacities, such as those with extensive forested regions. We will also speak to the principle of common but differentiated responsibilities for climate change mitigation and the obligations for international cooperation having regard to the essential borderlessness of the climate crisis. Climate change is causing harm, and if left unaddressed, will cause catastrophic and perhaps irreversible damage. So states must halt and reverse climate change and do so with a human rights approach, with proportionate diligence and urgency, supported by the best scientific evidence, with a gender-focused cultural relevance, and with intersectionality. As the Commission has highlighted in Resolution 3 of 21, The climate crisis impacts all human rights, directly and indirectly, especially the right to life, personal integrity, health, housing, access to water and sanitation, and food. And it also reduces the fiscal capacity of states to sustain development and to address the obligations for socioeconomic rights. The effects of climate change exacerbates inequalities within but also between countries, disproportionately affecting vulnerable and historically marginalized and discriminated populations. So we say states must enact policies to cut emissions, to enhance resilience, and to secure sustainable investments. And this honorable court has stated that states are required to use all available means to prevent significant environmental harm from activities within their jurisdiction. This obligation must be fulfilled following a standard of due diligence that is proportionate, appropriate, and proportionate to the specific risk in accordance with the precautionary principle. The magnitude of the damage must be quantified using factual and objective criteria. To this end, the Commission asserts that the implementation of environmental indicators such as air quality, water and soil contamination, or biodiversity loss should be considered. However, once environmental damage has occurred, the Commission has noted that the state's duty of prevention primarily translates into preventing its aggravation, mitigating its effects, adopting effective measures for adaptation, and responding to losses and damages. Regarding mitigation measures, states must rapidly implement robust decarbonization policies such as reducing all fossil fuel subsidies as much as possible, creating fossil fuel taxes, and redistributing revenues to clean, renewable, and non-polluting energy systems. Adaptation measures may vary according to the climate phenomenon, the population, and the region itself, so states should adopt a participatory and transparent approach in order to integrate them into socioeconomic and environmental policies.
Tanto el relator Palomo como yo hablaremos en...
Mr. Palomo and myself will speak in Spanish. Questions have been asked about the state obligations emanating from these procedural rights in the context of the climate emergency. The Commission highlights that access to information is crucial to ensuring the rights to life, integrity, a healthy environment, health, water, food, and sustainable development, as it enables the understanding of environmental risks from global warming, identification of effective prevention, mitigation, and adaptation measures, activation of control mechanisms, and the exercise of remedies to obtain comprehensive reparations. Under the duty of active transparency, states must proactively provide information about climate change generation, adaptation, and mitigation measures. Authorities must generate and disseminate information related to the climate emergency in a systematic and culturally appropriate manner. All information about development projects that potentially increase global temperatures with greenhouse gas emissions must be governed by the principle of maximum disclosure. States must have information systems focused on greenhouse gas inventories, sustainable forest management, carbon footprint, emission reduction, and climate financing. It is necessary to establish registers of emissions and transfers of pollutants to the air, water, soil, subsoil, and handling of materials and waste. The Commission emphasizes the importance of participatory mechanisms in decision-making about the climate emergency. Participation must be non-discriminatory, equitable, meaningful, and transparent, with adequate deadlines and relevant means. Groups directly affected must be identified to facilitate their effective intervention. The Commission and Redesca highlight that access to justice in climate matters must be guaranteed in accordance with due process guarantees. There must be avenues to act on access to environmental information and public participation in decisions related to climate change, as well as against any action or omission that may disregard obligations regarding the climate emergency. There is the duty to repair resulting damages, those resulting from climate emergency, must be analyzed, taking into account the specificities of the phenomenon. In the case of Chiara Sacchi et al. Versus Argentina, the Committee on the Rights of the Child pointed out that climate change affects human rights globally, even outside the territory of the emitting state. Furthermore, based on the principle of common but differentiated responsibilities under the Paris Agreement, the Committee resolved that the collective nature of the causes of climate change does not absolve states of individual responsibility for the damages caused by emissions within their territory. In this regard, the Commission and its special rapporteur emphasized that in the context of the climate emergency, states must comprehensively repair damages resulting from their actions or omissions, regardless of whether these occur outside their borders, are caused by lawful activities, or are the consequence of the conjunction of activities developed by various states. Thank you. I am Javier Palumo. I am the Redesca rapporteur. States have also inquired about differentiated measures that must be taken for populations in vulnerable situations or with intersectional considerations. The Commission Redesca believed that there is a reinforced obligation with regard to vulnerable groups as to the effects of climate change, including women, indigenous populations, and farmer communities, as well as children. That is why gender intersectionality must be part of the approach, and visibility must be lent to the aggravated risk. The Commission and Redesca emphasize that these communities live in areas that are highly vulnerable to climate change, which is a threat to their survival. And there is a need to have their free and informed consent when their territory is involved, and also their traditional knowledge must be integrated in strategies for mitigation and adaptation. What we seek is specific guidance about the differentiated rights of children and adolescents vis-a-vis the climate emergency, having in mind vector transmitted diseases and the increases in temperatures. All of these must be taken into account to prevent premature and unnatural deaths and the exposure to toxics by providing healthcare that is specialized, accessible, non-discriminatory, and that meet their specific needs. We emphasize the need to have early warning mechanisms to protect environmental defenders and create legal frameworks that sanction violations of their rights by companies and strengthen investigative capacities for crimes against environmental defenders. Moreover, states must implement measures against all forms of gender-based violence directed at environmental defenders, considering intersecting vulnerability factors. The frontline communities must be especially taken care of, as they're heavily affected by climate change. In line with the court's concept of collective guarantee, considering the significant diversity in the region, state obligations should vary within the framework of prevention, mitigation, and adaptation to climate change. In summary, states must prevent serious harm resulting from the climate emergency, apply the precautionary principle, and adopt mitigation and adaptation measures, establishing regulatory frameworks, effective monitoring, and enforcement systems. Additionally, they must ensure the production, dissemination, and access to information, establishing participatory and transparent mechanisms in decision-making about the climate emergency, ensuring access to justice and reparations. All this within a framework of common but differentiated responsibilities with the highest possible ambition and committing the maximum available resources. Thank you, Madam President.
Thank you to the representatives of the Commission. I will now recognize the representatives of the United Nations Special Rapporteurs on Toxic Substances and Human Rights and the Environment, and the Right to Development. Please proceed.
Thank you very much, Madam President and honorable members of the court, my name is Viren Mascarenas, and it is a privilege to be here before you at the instruction of the three human rights rapporteurs named by the President. The rapporteurs wish to make 6 points in these oral submissions. First, the climate emergency is having a disproportionate impact on the rights and lives of people in situations of vulnerability and marginalization. As set out in the written submissions of the rapporteurs, the climate emergency is interfering with a wide range of human rights. But this interference is particularly acute for women, children, indigenous peoples, and those living in poverty, whose adaptive capacity is limited by a lack of resources. Additionally, safeguarding the rights of the child and ensuring intergenerational equity are especially important to the rapporteurs. This court already has singled out the heightened duty to respect the rights of the child in the context of climate change. In paragraph 143 of the La Oroya judgment, the court found that states have a heightened duty to protect children and take action against risks to their health produced by the emission of polluting gases that contribute to climate change. Additionally, the rights of future generations are impacted by the actions of the present generation and those of the past. As this court explained in its 2017 advisory opinion, in its collective dimension, the right to a healthy environment constitutes a universal value that is owed both to present and future generations. And in La Oroya, the court confirmed in paragraph 129 that guaranteeing the interest of both present and future generations and the conservation of the environment against its radical degradation is essential for the survival of humanity. The second point is that the right to a safe climate is one of the substantive elements of the right to a healthy environment. Among the substantive elements of the right to a healthy environment are clean air, safe and sufficient water, healthy and sustainably produced food, non-toxic environments, healthy ecosystems, and of paramount importance for this advisory opinion from the rapporteur's position, a safe climate. This court has already identified a safe climate as being an integral component of the right to a healthy environment. It did so in paragraph 118 of La Oroya, listing climate as one of the substantive elements of this right. The third submission is that states have human rights obligations to address the climate emergency. In the context of air quality, the court held in paragraph 120 of La Oroya that states must establish laws, regulations, and policies, monitor air quality, perform action plans to control air quality, and implement measures to enforce air quality standards. In the context of the climate emergency, states are obliged to set an overall goal of net zero emissions by 2050 and set carbon budget pathways and targets to track progress towards that goal. Second, states must establish laws, regulations, and policies to regulate sources of greenhouse gas emissions. Third, states must develop and implement national adaptation plans to ensure that communities and infrastructure are protected from and are resilient to climate impacts. Fourth, states must monitor the impact of climate change and inform the population of related risks. Fifth, states must implement plans to reduce greenhouse gas emissions that prioritize the largest sources of those emissions. And sixth, states must regulate, supervise, monitor, and enforce laws governing business activities that contribute to and exacerbate the climate emergency. All of these tasks and obligations must be done using the best available science. A key relevant principle is common but differentiated responsibilities and respective capabilities. Parties to the UN Framework Convention on Climate Change and the Paris Agreement have repeatedly confirmed that the largest historical and current emitters must bear the lion's share of the burden of responding to the climate emergency. The fourth submission, in regulating businesses, the prevention and polluter pays principles are of paramount importance. States should enact legislation that require businesses to conduct human rights and environmental due diligence in their activities. This is complementary to environmental impact assessment legislation. Both are needed. In this regard, this court has highlighted that the principle of prevention of environmental damage is part of customary international law. This principle entails the obligation of states to carry out the measures that are necessary before causing environmental damage, taking into consideration that, due to its particularities, it will frequently not be possible after such damage has occurred to restore the previously existing situation. The polluter pays principle requires that parties responsible for the harm caused by the climate emergency should bear the cost of addressing that harm rather than externalizing those costs onto society. Fifth, states have extraterritorial obligations to prevent serious transboundary harm. The climate emergency is a global phenomenon that does not respect territorial boundaries. This court found in its 2017 advisory opinion that the state obligation to respect and ensure human rights applies to every person who is within the state's territory or who is in any way subject to its authority, responsibility, or control. A state is exercising authority over that person when that person is under its effective control, either within or outside its territory. A person's rights are violated if there is a causal link between the act that originated in a state's territory and the infringement of that person's human rights outside the territory. In the context of the climate emergency, states are obliged to ensure that polluting activities within their territory, jurisdiction, or control do not cause serious harm to the environment or peoples of other states or to areas beyond the limits of their territorial jurisdiction. This position has been affirmed by a resolution of the Inter-American Commission and was embraced by the United Nations Committee on the Rights of the Child in Sachi versus Argentina. The European Court of Human Rights, in its recent decision in Duarte Agostinho versus Portugal, articulated a narrower version of extraterritorial jurisdiction grounded in the specifics of the European Convention and the case law of the European Court of Human Rights, specifically addressing the issue that there was a divergence of jurisprudence with other institutions such as the Inter-American Court. The rapporteurs believe it is paramount to reaffirm the approach embraced by the Inter-American Court in its jurisprudence. And finally, sixth, access to justice with effective remedies is essential to holding states and businesses responsible when they fail to fulfill their human rights duties. States should ensure that domestic and international forums are available to hold states and businesses responsible when they fail to meet their obligations. A state's duty is to ensure a simple, prompt, and effective judicial remedy before a competent court or judge. To meet this obligation, states should ensure access to procedures and institutions that satisfy the following criteria. First, they are impartial, independent, affordable, transparent, and fair. Second, they review claims in a timely manner. Third, they have necessary expertise and resources. Fourth, they incorporate a right of appeal. And fifth, they issue binding decisions. Additionally, state redress obligations include those relating to loss and damage. States should cooperate to ensure that the recently agreed upon Global Loss and Damage Fund is swiftly operationalized and that it is adequately funded, primarily through contributions from wealthy and historically high-emitting states. To safeguard the right to redress, the fund should be independent, supported by a coordination mechanism, and capable of distributing funds directly to climate-affected communities. The rapporteurs thank the court for the opportunity to make these submissions. Thank you very much.
Thank you for your participation, the special rapporteurs of the UN. And now I give the floor to the representative of Sabin Center for Climate Change Law from Colombian Law School. Go ahead.
Good morning, and thank you, Your Excellencies, and thank you for the opportunity to offer these oral comments before the court. Underpinning the legal questions put forth in the petition are scientific questions about the nature of climate change, its impacts on people and the planet, the relative contributions of different state and corporate actors, and what different futures might hold. The Sabin Center's amicus brief addresses the relationship between climate science and the legal assessment of human rights obligations under the Convention. Our brief seeks to inform the court's decision-making by describing detection and attribution research, climate projections, carbon budgets, and their salience for this matter across a range of topics, including mitigation obligations, adaptation obligations, cooperation and finance, compensation for loss and damage, and participatory rights. Our brief offers a number of key preliminary conclusions. First, there is a strong evidentiary support for the finding that climate change poses an actual and imminent threat to a broad range of human rights. Climate change harms are happening here and now, in many cases posing a direct threat to human health, lives, livelihoods, culture, development, self-determination, and the ecosystems and natural resources that humans depend on. The severity of these harms increase with every increment of warming. Many more people and ecosystems will be at risk if anthropogenic warming is not limited to 1.5 degrees Celsius above pre-industrial levels. Second, states must achieve deep and rapid reductions in greenhouse gas emissions this decade in order to achieve or have a real chance of meeting the Paris commitments. States need to enact regulations aimed at phasing out fossil fuel production and use, and at reducing greenhouse gas emissions from other sectors, including agriculture, livestock, deforestation, and other land use decisions. States need to reduce emissions of both carbon dioxide and more potent greenhouse gases, such as methane, which have a larger effect on near-term warming. On this point, I would refer the court to the recent decision from the European Court, especially paragraphs 114 to 120, which address the IPCC's findings on this issue in detail. There are a number of ways climate science can be used to characterize the differentiated responsibilities of states with regard to emissions and climate damages. While I commend the entirety of the brief to the court, I'm going to focus today on this issue and the relationship between attribution research, carbon budgets, human rights law, and states' mitigation obligations, or what's sometimes referred to as their fair share. The central point I would like to underscore for the court is that all countries have an obligation to establish and implement domestic laws and regulations aligned with the internationally endorsed scientific consensus. While the countries most responsible for the climate crisis must take the lead in mitigation and adaptation, as well as in finance and loss and damage compensation, all countries have an obligation to mitigate, bearing in mind the principle of common but differentiated responsibilities, the need to tailor action to the domestic context, and the need to protect the rights of vulnerable populations, among other things. There are a number of different types of science that our brief focuses on: climate change attribution, impact attribution, extreme event attribution. I'd like to focus now on source attribution, which examines the relative contributions of different sectors, activities, and entities to climate change and its impacts. While most of the science in this area addresses aggregate effects, recent developments in the science have advanced our understanding of the significance of smaller scale and even individual contributions. For example, there is a near linear relationship between cumulative CO2 emissions and observed declines in September sea ice in the Arctic. And researchers have estimated that each ton of CO2 that is released may result in a sustained loss of approximately 3 square meters of that September sea ice. Other studies have demonstrated that it is possible to quantify the proportional contribution of individual countries to specific extreme events using the example of the Argentinian heat waves of 2013-14 and 2023. And another study used historical emissions data and climate models to quantify each country's responsibility for historic temperature-driven income changes in all other countries, concluding that the top 5 emitters, the US, China, Russia, Brazil, and India, had collectively caused $6 trillion in income losses from warming since 1990. While that study uses gross domestic product losses attributable to warming rather than providing a detailed sketch of more individualized impacts that add up to it, it underscores that methodologies exist and are being developed to help states assess state responsibility for climate harms. As noted in the brief and as reflected in the European Court's recent decision, a number of legal authorities have found that states have an obligation to control and reduce emissions from sources under their jurisdiction to prevent harm and protect fundamental human rights. This obligation is rooted in principles of human rights law, customary international law, treaty law, and domestic constitutional or common law, and is often assessed in relation to standards articulated in the UNFCCC agreements. Climate science serves as the principal evidentiary basis for characterizing these obligations and determining whether states have breached those obligations. Drawing on this case law and the science underlying it, we propose several principles to inform this court's assessment of states' obligations. First, all states share responsibility for climate change, and while it is true that no one state can totally prevent climate change, it is also true that there is a causal connection between emissions attributable to a state and impacts both inside and outside of the state. This was one of the central findings of fact that informed the trial court's decision in Held versus Montana, a state-level court decision in the United States, and that's this. Every ton counts, and state reductions will mitigate the harmful effects of climate change, even if it does not halt them. This court stated in the advisory opinion on the environment and human rights that a causal connection is required. Courts have never required a high level of granularity or precision, a one-to-one correspondence, when it comes to assessment of this question in this context. Here, the climate science supports the conclusion that a sufficient causal connection exists and would indicate that in any individual case, the presumption should run in favor of causation rather than against it. Second, all states must be held to greatest possible ambition standards and must adopt policies and regulations aimed at reducing greenhouse gas emissions to net zero as quickly as possible, taking into account, of course, their respective capacities and resources. This is consistent with the more general principle that states should guarantee human rights to the maximum extent possible, as well as the precautionary principle, the no harm rule, the duty to prevent transboundary environmental harm, the duty to cooperate, and the CBDR principle. State mitigation obligations should also be interpreted in light of attribution science and carbon budget analyses. While the court has not been asked to characterize specific reduction obligations for individual states, the request does seek clarification on the nature of state duties to prevent climate change and the principles that should animate national action. To inform an opinion on this matter, we need to know who has contributed, how they have contributed, how much they have contributed, and how it all fits into that obligation to mitigate. There is some academic research on equitable allocation of the global carbon budget among different countries and sectors. This area of research implicates physical climate science, but it also deals with ethical and normative questions that could have salience for how this court assesses national mitigation obligations. For example, how to account for historical emissions, population, development status, and other differences among countries. This research identifies specific indicators or metrics that are relevant when assessing national fair share and demonstrates how those indicators can be factored into quantitative assessments of greenhouse gas emission reduction targets, and that's at box 3A3 in our brief. The resulting obligations in that analysis depend on the weight assigned to these different metrics and the specific circumstances of the country being assessed. I do not mean to imply that this research answers the questions posed to this court, but it can be used to help inform an evaluation of the sufficiency of mitigation targets and measures undertaken by states, and should alert the court to the fact that methodologies do exist by which these factors can be rigorously taken into consideration. So finally, I'd like to just propose several more principles that may be relevant to the court's consideration. State responsibility for climate change should be predicated on a holistic assessment of greenhouse gas emissions attributable to the state. There are a number of different ways to attribute emissions. This is typically measured in reference to the state's territorial emissions, that is, emissions from within the state, but other measures are also critical to understanding a state's actual impact on the climate. Consumption-based emissions, the emissions that result from the manufacture of goods outside a territory that are imported into it, can help determine whether states are essentially outsourcing their carbon emissions upstream. Production-based emissions, the emissions that result from fossil fuels extracted within a territory and exported elsewhere, or perhaps even just transported through a territory, can illuminate whether a country is outsourcing its emissions downstream. To understand the ways in which a state's policies impact human rights, a court should have awareness of the totality of these circumstances. Second, state responsibility should be assessed in light of the state's cumulative emissions, as this provides the best estimate of a state's actual contribution to climate change and associated threats to human rights. Finally, it is clear that emission reduction targets in NDCs and other pledges are not sufficiently protective of human rights. These should be viewed as a floor for state obligations rather than a ceiling, and courts assessing the adequacy of state mitigation ambition in a human rights framework should be able to look beyond them. Ultimately, even where a court lacks jurisdiction to establish numeric greenhouse gas emission targets for a state, it can use carbon budget and fair share research to evaluate the sufficiency of existing targets and policies, and to determine whether more ambitious net measures are necessary in order to protect human rights. The science is clear. Climate change poses a real and pervasive threat to a broad array of human rights, and states must undertake ambitious mitigation and adaptation measures in order to prevent and mitigate harm to people and ecosystems. Thank you very much for your time.
Muchas gracias. Agradezco la presentación del Sabin.
I thank the Sabin Center for Climate Change Law. Now I give the floor to the Inter-American Association for the Defense of the Environment. Please proceed. Good afternoon, Madam President, Honorable Court, delegations of states, the Commission, colleagues, members of the community, victims of the impact of climate change present in this hearing. My name is Liliana Avila. I'm the Program Director for Human Rights and the Environment for the Inter-American Association for the Defense of the Environment, AIDA. Science is unequivocal. The current levels of warming are already hurting human rights, and every fraction of degree of additional warmings exacerbates this impact and reduces the ability to adapt for persons and ecosystems. Science has also taught us that the noxious effects of climate change are disproportionately affecting persons and systems that are the most vulnerable, and some nature and human systems have been pushed beyond their ability to adapt. Climate change disproportionately affects certain groups: children, women, the elderly, persons living in poverty or with disabilities, and communities that have a vital relationship with their territories, such as indigenous populations, farmers, and subsistence fisherfolk. In the initial vulnerability stemming from historical inequality and discrimination is aggravated by climate change. Science has also identified anthropogenic activities that have contributed the most to the climate crisis. And the countries that contribute the most to this climate crisis and those that are most vulnerable to it. The exploitation and burning of fossil fuels and agri-industry have had a major impact on human rights and have altered the global climate system. Faced with this scenery outlook, the states have undertaken to make all efforts to prevent temperatures from going over 1.5 degrees from pre-industrial levels, but science tells us that efforts made until now are not sufficient. The model suggests that the current policies that states have undertaken to follow since 2019 would lead to an increase of 2.3 degrees in temperature, as is shown in the global balance during the last conference of the UNFCCC. In spite of progress, the parties are not yet on track to meeting the purposes of the Paris Agreement and its long-term goals. So this outlook shows that the interpretation of the obligations undertaken vis-a-vis climate and human rights cannot be subject to the discretion of the states or companies that over decades have been told and warned about the impact of their actions and omissions on the climate system, and in spite of that have not taken sufficient action. Honorable Court, this is not just a climate emergency, it's also a legal emergency. That is why the Inter-American Court is faced with a unique opportunity to generate standards that will promote the protection of human rights in the context of climate emergency, as was the case with OC 023 of 2017 on human rights and the environment, and also in the case of La Oroya, which has been brought up several times during this hearing. It is fundamental to recognize that the obligations of states vis-a-vis climate change are not limited to the commitments undertaken under the UNFCCC. Many of the submissions to be heard today will have to do with different issues. We would like to focus on 4 aspects that we believe are fundamentally important. First of all, it's important to recognize the human right to a stable and healthy climate. And this stems from other rights that are enshrined in the American Convention, such as life, the environment, and the right to humane treatment, which are cataloged as fundamental by this court. Secondly, the protection of the right to a stable and safe climate means that the states are under the obligation to take all actions to face the climate emergency through regulation, supervision, and oversight of greenhouse gas emissions by sources under their jurisdiction. Limiting the impact on human rights stemming from climate change is something that can only be done through an in-depth and swift reduction over the next 10 years of the sources of greenhouse gases. Every unit that is released into the environment contributes to the climate emergency. No state can fully prevent that from happening, but every effort to reduce greenhouse gases emissions will help, and this is part of the principle of common but differentiated responsibilities. States must also undertake to take the most efficient action in a context of efficiency. We are racing against the clock, and often our leeway has become more and more limited, and science has shown that greenhouse gas emissions have immediate effects, and they need to be reduced immediately, swiftly. As the Commission said, states are under the obligation to adopt and implement policies to reduce GHG emissions that are as ambitious as possible. Therefore, it's urgent for states to do at least three things. First of all, to promote the reduction of short-lived climate forces as one of the best and most cost-effective ways to limit the increase in temperature. And together with the plans to reduce these pollutants, there's a need for energy transition to be moved forward. 50% of gas reserves and 30% of oil reserves as well must remain unused if we want to stay below 2 degrees warming, and a significant number of reserves if we want to should remain unused if we want to stay at 1.5 degrees. The COP requested that the parties take action to treble the renewable energy capacity and double energy efficiency by 2030, and also scale up the phasing out of carbon and also reducing inefficient subsidies to fossil fuels. It is necessary that the transition be done in a fair, orderly, and equitable manner, and that it be led by developed countries. This is not just about making a change to the power grid. The exploitation of fossil fuels is directly linked to the violation of human rights enshrined in the American Convention that has been seen through the petitions, cases, and requests for provisional measures by this court. It is necessary for human rights to be respected, for this transition to be fair. It is necessary to develop standards for the mining activities so that they do not violate human rights. The extraction of lithium, copper, and others, which are so abundant in our region, may exacerbate environmental conflicts and affect indispensable ecosystems for climate stability and also for the subsistence of the traditional way of living of some of our communities. States must also take action to face the reduction of the capability of adaptation due to the uses of soil deforestation. Latin America is one of the areas in the world with the swiftest loss of primary forest, and this creates more vulnerability for the communities. This legal emergency calls for effective guarantees for access to justice. This emergency calls for national and international justice systems that guarantee the rights in the material sense of the word. And there's a need to do away with barriers that are regulatory, social, or of a different nature, that also we need to protect human rights defenders who have been a victim of this process. We need to include the possibility for any citizen, regardless of age or social status, can demand the protection of their rights in relation to the climate emergency, and also have standards of proof that do not limit that demand for rights, and that there may be changes to the burden of proof, recognizing the state of attribution research and conventional knowledge, traditional knowledge. We must repair damage derived from this climate crisis for human rights, and this is a principle of international law. Those who have transformed the climate and have created material and immaterial damage must repair them.
Thank you for the Inter-American Association for Environmental Defense. We will now begin questions from the judges. Judge Patricia Perez-Goldberg, do you have any questions? Yes, ma'am. Thank you. No, ma'am. Judge Perez-Goldberg, do you have questions? Yes, for the Inter-American Commission on Human Rights, especially for the rapporteur of Redesca. Could you perhaps speak briefly about the common but differentiated obligations of states, which is something that has been mentioned by almost all of the speakers? Please proceed. Thank you for the question. This question necessarily is linked to international cooperation, and it starts in our region with the importance of recognizing the enormous diversity between the position of certain states and others concerning the position of the more developed countries versus those that are in development justifies the fact that the former are not only under obligation to implement prevention measures and mitigation measures directly involving the activities they carry out, but also they should cooperate substantially with the other countries, such that the developing countries would also be able to increasingly adopt measures of prevention and mitigation. This requires commitments that would take the form of resources, which would be translated into technical cooperation. The president of the Commission was very clear when she talked about countries that have different types of situations, especially their experience with the impact of climate change. The region is very rich in diversity, and it's also very rich in the sense that there are countries that have industries that have been causers, that have caused these consequences that we are discussing in today's session. Implementing the commitments for climate change should include consideration for the situation of the countries that are more vulnerable, countries that are experiencing the adverse effects of measures and responses to climate change. And also, as part of the development of international human rights law, the obligations of the states for the climate emergency must be proportional and must be determined based on the consideration of their responsibility for issuing greenhouse gases, and also their financial and technical development in order to prevent and mitigate and adapt to global warming. This is why this is so closely connected with the Inter-American Decision in the sense of international cooperation, and this driving idea concerning shared common but differentiated responsibilities and the obligation to give them material form through mechanisms for cooperation among countries that have different positions regarding this phenomenon. Thank you. Thank you. I have a second question for the Sabin Center. Michael Dwaga,
so it's good to have them, but states do have to look beyond. So how that looking beyond, because we, Paris Agreement, Tokyo, etc., CCC, they have been mentioned again and again, and how we have to link this interpretation that we have to make of human rights obligations to those treaties. But what is the role of the interpreter of the human rights treaties in connection with this obligation to look beyond those minimum standards? Thank you.
Thank you. Given that the NDCs and commitments that have been made by national governments are not adequately aligned with the science-based recognition of where we stand in regards to the climate emergency, in order to promote and protect human rights, I don't think that it would be sufficient to accept voluntary pledges that are made at the national level as the final word in terms of whether a country is abiding by and compliant with its human rights obligations to its own residents and to those abroad who it may be causing transboundary harm to. And so in that respect, we heard earlier today a reference to the relationship, and we've heard throughout relationship between the Paris Agreement and the UNFCCC process and human rights, and whether these are, one is primary to the other, whether they are independent in some way. In this regard, I think that they are complementary, which is to say that the Paris Agreement, pledges made through the Paris Agreement process may or may not be adequate. And the human rights lens offers civil society and those who may not have adequate access to the political process through which the NDCs are created, an opportunity to challenge the adequacy of government commitments.
Thank you very much. Last question, Mr. Mascarenhas, on behalf of the rapporteurs. You mentioned in a very emphatic way the principle polluter pays as a paramount. How do we avoid the trap in which we've been for many decades now, in which polluters pay and continue polluting?
Thank you very much for the question. The rapporteurs do wish to emphasize that this was an important principle for them on prevention, and then separately also on polluter pays. So I'm glad that it was emphatic in the delivery of that. Throughout the submission of the rapporteurs, a key focus was on this issue, that there may be new advancements, new investments, new developments in how to fight against climate change through mitigation and adaptation, but that they may not sufficiently take into account the human rights impacts of what all of those measures are. And so there's a focus then in the rapporteur submission on the polluter pays principle based both on states and those historic high-emitting states having an obligation, both on themselves and also on those within their territory or those over whom they have the control for being responsible for those historical emissions. We would actually agree with much of the submission made by the Sabin Center on this point regarding the baseline in which national NCDs could be used, but have to be supplemented through a human rights analysis of whether this is good enough. And the ending point actually on the procedural grievances that those in civil society or those whose human rights are being impaired could challenge whether that polluter pays principle is being applied or not, or whether the NCDs have been set at a sufficiently high level or threshold, would be a role then in which such discrepancies between what has been done in terms of damage and what is being paid for, accounted for through NCDs or other sort of reparation schemes is sufficient. So there's a procedural element there to ensuring the polluter pays principle is effectively implemented. There's also the reality then for the loss and the loss and damage fund that's being established here. In many ways, it was heard earlier today about the submissions from some of the countries that this is voluntary contributions that may not be enough. It is very difficult for the court to do this in the abstract, especially in an advisory opinion. We recognize that. But sort of pronouncements or recognitions on measuring up the historical emissions of states, both within their territory or even where they have extraterritorial link, should be part of the calculus for determining what those contributions should be. Sort of a methodological guide to states in what they should be considering when calculating sort of their contributions as a result of the polluter pays principle.
Okay. Thank you very much.
Thank you, Judge Veronica Gomez. I now ask Ricardo Perez Manrique. Judge, will you have questions? Yes, Madam President, thank you. First, to the Inter-American Commission. I heard in the special rapporteur's words that there is a reference to the principle of collective guarantees. So if you could please expand on this, please. How is that linked, the principle of collective guarantees, to climate change? Thank you for your question. The Inter-American Court on Human Rights developed its concept of collective guarantee and highlights that it underpins all the inter-American system, especially when the court refers to solidarity and goodwill among states in the American continent. From that perspective, we've highlighted that as per the mechanism of collective guarantees, it is incumbent upon all states to cooperate with each other in good faith to fulfill their international obligations, both regionally as universal. And based on this conceptual development by the Inter-American Court on Human Rights, we consider that we can reinterpret this principle of common but differentiated responsibilities that is present in the Declaration of Stockholm and the Rio Declaration on the Environment and Sustainable Development, the Framework Convention on Climate Change, that helps us enrich the concept and the principles of the Inter-American system by interpreting other texts, which aspect the Inter-American Court on Human Rights has done for many years now, starting with the Corpus Juris on the protection of the child up to our days. So following that same logic, it seems feasible and reasonable as well as positive to reinterpret the American Convention by applying this specific concept of collective guarantee, considering the principle of common but differentiated responsibilities. Thank you. Thank you. Another question to the Commission. In your brief, you highlight that states have to go beyond their current commitments to fill the gap between what has been promised and what is necessary. What are the expectations? Or what are the requirements? What's the difference between what was promised in the agreements and conventions we know about and the standards, and what is necessary to address this issue? Thank you once again for the question. Scientific development is providing the guidelines for us to establish our data, our way to say what is necessary in terms of reducing GHG emissions and trying to avoid global warming. So that is established. There's consensus scientifically in different scientific discussion fora in the United Nations. So most importantly, from the perspective of the Inter-American system, we have to bring these baselines, these developments, and include the obligation of progressiveness or progressivity that has been developed by the Inter-American Court on Human Rights, which is to adopt requirements to ensure effectiveness of the rights involved, always to the extent of the economic and financial resources available to fulfill that international commitment. There's a need to standardize what you promise to the obligations of international human rights law. Some discussions are being held in spheres that are not necessarily referred to international human rights law. As the court knows, this advisory opinion brings together environmental international law as well as international human rights law. Each of them have their own principles, and a good part of the work that is ahead of the court and that means to bring these principles together should be part of the considerations when preparing the advisory opinion. Thank you. Thank you. We still have to determine what is necessary then. Just one request. You have mentioned the people that are migrants or climate migrants or climate refugees. What standards can serve to address the needs of this vulnerable population? Thank you for this question. There is some work in the United Nations, specifically the Human Rights Committee of the United Nations, which I believe could be very interesting. The decision on the case of Joan Teitot, sorry for the pronunciation, the committee has developed decision on the possibility of asking for asylum based on climate consequences. This is on October 24th, 2019. In case you want to look the case up, I'm sorry, I wasn't clear on the name, so you can look it up with the date. And this case referred to a citizen that requested asylum in New Zealand. The person lived in an island nearby and requested asylum in New Zealand because of the effects of climate change and the rising sea levels. He was forced to migrate from his home island to New Zealand. And although the committee did not find any specific violations, they did develop certain elements that could help future refugee requests based on climate change and the possibility of justifying the adoption measures and the possibility of providing refugee status because of the effects of global climate change and adverse effects, as long as there's imminent risk to the life of the asylum seeker. We're dealing with a committee that regulates international law on refugees, and they've had many decades existing now. It was created in the 50s, so these are international bodies that are reinterpreting their own standards as well that date back several years to be able to move forward with protecting imminent risks to people's lives because of the climate emergency. Thank you for the question. Thank you to the Commission for answering my questions. I now have I would like to ask clarification from the association, the Inter-American Association to Defend the Environment. In your brief, page 19, you refer to the connection between corruption and climate action. Could you please give us more detail? Could you repeat, please? Yes, I've written down here that on page 19 of your report, or your brief, you mention a relationship between corruption and climate action. Am I correct? Or am I mistaken? Thank you, Your Honor. I would like to offer two elements on corruption and climate action to answer your question. First, regarding actions taken by fossil fuel companies over several years to evade their responsibilities or to deny the existence of climate change, and consequently to limit actions by states and communities that are affected to obtain reparation and measures to fight climate change. This is a very important element in all climate action. In the conferences of parties, we see large delegations of fossil fuel companies lobbying with delegations of the states to condition measures. And again, this is a very important measure, a very important element, part of the measures taken by states, or that should be taken by states. And courts should also consider this to guarantee transparency, access to justice, and open dialogue and debate, and how these types of companies intervene in negotiations and all the politics related with climate change. Thank you very much. This question brings up a fundamental aspect that is not always addressed, especially in venues such as this. We are talking about corporate capture, and we have to address this as well. We're not just talking about a climate emergency, we're also talking about a legal emergency. So the way you address the specific problem of corporate capture, both in negotiations, where we've referred to international negotiations of the Paris Agreement, the UNFCCC and others, but also in how the legislation is being implemented, not just in how public policy is designed, but it's how we access justice. This has to also be more specifically addressed. Corporate capture is part of what we were referring to, or at least partly, yes, in this connection. Thank you for the answers. And to the Sabin Center, I will try to summarize my question. You have provided an approach to the best science available, in a way, all the types of consensus that have been reached, and how you can accredit this. This is what we can draw from your brief. So I have two questions in a single one. What are the rules or the criteria to determine what is the best available science? And two, whether that best available science allows us to assess or determine whether the limits that are established by the Paris Agreement, the 1.5 degrees, are truly responding to the best available science. Did I make myself clear? Thank you.
Thank you. As I understood the question in translation, the criteria for the best available science, I think in looking at how courts around the world have treated the question of scientific evidence in climate cases, the simple answer is the IPCC's science is the best available science. And then you can go sort of next to regional, national, or international organization science, where you have either assessments that are conducted at a national level or otherwise sort of government-endorsed or intergovernmentally endorsed scientific reviews. There is also the cutting-edge science, right? Science is always an act in progress, and climate science is very much a work in progress on many fronts. Some of it is more cutting edge than others. And there, courts have not yet been challenged to really get into the nitty-gritty of the battle of the experts in many instances. We have limited instances in which courts have been asked to do so. So again, the best available science, I think, will consist of the IPCC science, and then there are other levels to that. Does the best available science allow us to determine whether the Paris limits are responsive to the needs of the climate crisis? I guess one way that I could understand that question is 1.5 degrees adequate, or is well under 2 degrees adequate? And my understanding is that the science has steered us very firmly in the direction that 1.5 degrees is necessary, And anything above that, each increment above that, will result in greater impacts. And that the impacts at 2 degrees are far different and far more extreme than the impacts at 1.5 degrees. Whether the 1.5 degrees is truly feasible at this point is in some sense perhaps a moot question, because what we do know from the science is that we need to limit the global greenhouse gases as much as possible, as quickly as possible, to avert the worsening effects that we're looking at. I hope that answers your question.
So precisely based on your response, you've said that the best available science has determined that 1.5 is a level that is at least necessary. So my question was whether it is sufficient.
5-degree level is sufficient to protect human rights, or whether we need to go further than 1.5 degrees.
Sí, exacto.
I'd like to say yes, we need to go past 1.5 degrees. We need to stop it now. But we already have 1 year from a 12-month period in which we've been above 1.5 degrees. And so I'm not sure that it's possible.
Bien, muchas gracias.
Thank you very much, Madam President. No more questions, and thank you for your answers.
Vicky?
Thank you, Judge Perez Manrique. I will now ask Judge Eduardo Ferrer MacGregor if he has any questions. Yes, Madam President, and thank you so much. Along the lines of the questions asked by Judge Perez Manrique, also for the representative of the Sabin Center, in climate litigation before a judge, the attribution of damage, is that what is sought, or is it enough to deal with the issue of due diligence? In light of what you have seen, basically, I mean, you mapped this out quite well. You know about these climate litigation.
The attribution, so let me first of all apologize. I didn't actually introduce myself when I began my remarks. Michael Berger, I'm the Executive Director of the Sabin Center for Climate Change Law at Columbia Law School. The attribution of damage to individual defendants, whether at a state level or a corporate or industry level, has not reached conclusion in very much climate litigation to date, if any. The allocation of damages in the form of compensation to individuals is being litigated. But we have not yet seen exactly how that's going to play out in the end, and the different contexts in which we see it in different countries, in different jurisdictions, under different theories, different causes of action, lead to different kinds of scientific or evidentiary questions that may come up. What we have seen is successful determinations of responsibility to reduce emissions based on a quantitative attribution of emissions to corporate defendants. And we have seen directives from courts to national governments that they must be more ambitious in that, based on the inadequacy of their pledges, or their not their pledges, but their climate policies to date. And that also requires an attribution of some responsibility for the damages that are being experienced by the people bringing the litigation to those activities. I hope that answers your question. I'm not sure that it did.
Sí, y aquí lo voy a relacionar.
Yes, but I am going to tie this to something that was mentioned by Idea about the standard of the standard of proof. You mentioned it in your written submissions as well, Aida, but I'd like to hear more about this aspect when it comes to climate litigation. Thank you for your question, Your Honor. Cases involving human rights violations due to climate change are very particular because they have to do with causation, with cumulative impacts and cross-border effects. And in that regard, they call for national and international courts to adapt to the needs to respond to these demands for material justice in these cases. So what we've said once and again is that it is necessary for the standards of proof to be modulated in scenarios where one of the parties is in a better position than the other due to the ability to produce proof, evidence, and that is the party that should provide the best information about actions and omissions that underpin the factual debate in the case. But aside from that, it is also important, of course, to have attribution science and all of the progress that has been attained by science in terms of identifying the impacts of climate change and how those impacts are reflected in certain ecosystems. Oftentimes, what courts have said in environmental litigation is, well, applying the principle, the cautionary principle, and he who alleges that there has been the burden of proof is on he who says that no damage has been caused. But it is also important to go back to the importance of recognizing the communities and their knowledge about climate. They have their own knowledge about the makeup of the ecosystem and the changes and how the changes in these makeups have changed their lives. And that's one very important way to provide evidence for cases. And it's important for domestic and international courts to include that traditional knowledge as part of the proceedings before them. And courts have done that through on-site visits. This court has done it. Others have done it through expert witnesses and through intercultural dialogues that are so important in these scenarios of legal emergency. So the idea is to be creative and use that toolbox that is available to have access to material justice in cases where it is needed as a matter of urgency. So as to help us be creative, what good practices are you aware of in the courts? What are those good practices you can tell us about? The Constitutional Court of Colombia, in several situations, has brought in the principle of the precaution and prevention. I think that all advances of the everything having to do with the right to a healthy environment is important when it comes to the protection of rights in contexts involving climate change. In that regard, the courts at the domestic level have developed several tools that may be of interest when time comes to build proof. In several countries, we've seen how courts reach out to communities, and through different processes, they can receive taken evidence. And as part of their rules of procedure, they have seen, or in their rules, they've seen asymmetries, differences in the way that proof and evidence is produced. Another one has another issue that is important, is environmental impact studies. And they should include climate components. That's not done by very many countries. And also, this climate impact studies should include scenarios where these studies, these are done independently. Now they're undertaken by the companies, and of course there's a conflict of interest there because the companies want for the project to go ahead, and environmental impact studies end up with the findings that they wish to be found. So the proposal on our part here is to have independent scenarios where companies either pay third parties and outsource those environmental impact studies, or that where states within their own powers, environmental powers, do those environmental impact studies independently, have them done independently, and that there be a dialogue that is necessary with the communities, that they be in keeping with those dialogues, because it is only the states that can guarantee independence in contexts that are unequal, disparate, involving companies that are in areas where people live in vulnerable conditions or in historical exclusion. The difference that we see in cases where you have to have access, about the burden of proof, what we've seen in certain states of the region is that there has been a reversal of the burden of proof, and that's under the Escazú Agreement, for example. So the burden of proof would be on the person who is arguing that it has not breached human rights in the context of the climate emergency, or whoever has access to that evidence. If I may add, I think this is also a key aspect that the court has a precious opportunity to help in this war involving David and Goliath. We know who David is and who Goliath is. All these companies, these transnationals, have all of the money, everything available to them, and that's why it's important to revert the burden of proof. And these studies are very costly, or sometimes they don't have the scientific means to be able to do this work of attribution, this causal relationship that exists. But that falls to the states. There's the duty of due diligence. There's the whole administrative and legal system is in place for environmental impact studies to take place, before the fact. We need to prove who was responsible for the damage. We might not be able to do it, but we can tell the stakeholders what they should do for this not to continue down the same path, which has led to this climate emergency. And finally, you referred to a right which is autonomous, the right to climate stability. Is that an independent right, or is this derived from the right to a healthy environment, or how does it stem from the Inter-American Corpus Juris, from the American Convention, the Protocol of San Salvador? Could you please elaborate on that? Climate is an essential element to human development on Earth. And we've heard this from all those who spoke before us, the importance of climate in this regard. And the court has also spoken about this at length, and about other rights derived from the right to a healthy environment, as was in indigenous cases about the protection and recognition of the right to water. And then there's some important content in there. And in the La Oroya case, the right to clean air, and also develop the content and the scope of that right. So when we talk about the right to a stable climate, we recognize that climate is part of the components of a right to the environment, an environmental right, but that is directly related to other rights considered fundamentally important by fundamental rights such as the right to life, and humane treatment and a healthy environment. And that's how we built this, based on the importance of the, seeing the existence of a right that is independent, but also in light of the effet utile that it has in terms of recognizing the right to life or humane treatment. So in the context of a climate emergency, that right needs to be recognized. And we also feel it's necessary due to, in light of the need for enforceability. It's important for national courts and the climate movement and communities that are affected by climate to be able to demand their rights in the court system domestically. And this should be included in specific obligations having to do with reduction of emissions, greenhouse gas emissions, regulations about the energy transition and how it has to be fair, and how the NDCs should be compatible with the maximum ambition possible. So that's what we have to say about this. Right. If I'm not mistaken, it's a component, isn't it? This right to the environment. Right. First of all, on the one hand, climate is part of the environment, and the environment is considered fundamentally important to human existence and to the materialization of other substantiation of other rights. But this right does not stem necessarily from the right to a healthy environment, but rather to other rights, such as the right to life and humane treatment. All right, thank you. That's all.
Thank you, Judge Ferrer McGregor. I would now ask the judge.
No, Madam Chair.
Pérez Goldberg me manifestó interés de hacer una pregunta. Adelante.
Sí, gracias, presidente. Muy breve. Cuando el juez Pérez Manrique hizo una pregunta vinculada al principio de la mejor ciencia disponible, y bueno, el representante Sabin Center aludió al informe del IPCC, me quedé pensando en un aspecto que no ha sido abordado y que me gustaría aprovechar la instancia de consultarles, que es justamente lo que ha dicho.
I would like to know what the expert view about transportation as one of the sectors that contributes the most to emission, especially of carbon dioxide gases. I would like to hear your thoughts about this subject, considering that during this session, when we in our last session when we discussed care work, mention was made of the possibility for reconciling personal well-being with labor rights, and here we talked about telework as an initiative, along with better public transportation and other things which the government and private companies can offer, and that would contribute to and similar and this would also improve greenhouse gas conditions, because transportation is one of the most contaminating industries, and public transportation helps. I would like to hear your thoughts on the subject by the Commission and the representatives of the rapporteurships, and if you have any thoughts on the subject, I would like to hear that. It's a bit difficult to. Thank you for the question, by the way, Your Honor. It's a bit difficult to address these subjects involving reduction of greenhouse gases, considering that it's a strategy that focuses on just one facet, one type of activity. In principle, the idea of developing and applying laws and measures on the subject in order to bring about a reduction in the emission of GHGs would need to be comprehensive. If there is scientific evidence available that a certain specific activity has an impact, a greater impact, or a more significant impact, then we would have to focus on that through rules, regulations, standards, monitoring, supervision, in order to bring about the changes needed to bring about that type of success. A similar discussion is taking place regarding the developments for energy transformation. It's very clear and more than evident that because it points toward this comprehensiveness and going to the heart of things. Don't think that the transportation sector all by itself is a sector that burns fossil fuels in a way that is out of proportion to other sectors of the economy, but instead think about a specific problem that which lies at the heart of it, which is the production of fossil fuels in order to for mobilizing the transport sector. But there are many other, and also many other sectors of the economy. From that perspective, the main developments and the main demands, regulatory demands, public policy needs in the states are given with respect to the decarbonization, as it's called, which is being used, which is in all the sectors of the economy are trying to use as little as the least amount possible of fossil fuels, with the idea of transforming the energy, the power grid. The problem, which has been very clear in the question by Judge Perez Manrique, is how to measure it and how to determine how much is enough in that sense. And the other question from that perspective is that there is consensus developed in international spheres, very often scientific spheres, which involve setting guidelines, but also there are communities that come before the organizations for human rights protection that are saying that it's not enough. When we, on the Commission, and Redesca, when we paid our in-local visit to Colombia, we saw the communities being affected by climate change and the climate emergency, and we realized that even beyond any commitment acquired in these international organizations, and nevertheless, what's knocking on the door of these organizations is the life and welfare of communities that have been requesting protective measures that we see when we pay our in-local visits. This is the development and the attention that is needed. It needs to be handled in the framework of this discussion. Again, it's not just, from my own perspective, it's just not just a matter of carrying out a concrete activity, in my view, but rather developing a whole process of decarbonization and addressing energy transition as a whole, and understand that many of the agreements that are developed every day do not consider the human rights perspective. Only a few months ago, I was invited to a side event to the meeting of energy ministers of the Americas, where they were not talking about human rights. They were talking about energy transition, but they were not talking about human rights. I think it's very important to understand that a number of debates and discussions and developments are taking place in spheres where the perspective of those of us who work in human rights and have direct contact with the communities are not present. Thank you. Thank you. Just to make sure, we talked about complementary considerations here and also simultaneous. That is to say, my question, it goes to the initiatives of the states for policy decisions, for the impact of the power grid and decarbonization, but other measures could take place in parallel and that are connected with the development of companies and human rights, and how these two aspects are interconnected, and how measures could perhaps take place on a parallel footing, but also simultaneously. So my question is about that. In the fifth evaluation report by the IPCC, we see reference being made to the enormous impact of highway transportation when you talk about greenhouse gas emissions. And so I'm wondering, For example, how? By connecting human rights institutions to companies, or there are European guidelines about how companies can adopt plans for sustainability using innovative measures, and I would like to know what you think about that.
The rapporteurs, when we were putting together the written submissions, considered whether to present the impact of different industries in causing greenhouse gas emissions. In section 6 of the written submissions, there is a discussion of what states should consider doing in the realm of policy in different industries. The rapporteurs were conscious of not exceeding their expertise, which is to focus on the human rights impacts that are under consideration here. But there was a presentation then on the major sources of greenhouse gas emissions, in particular the phasing out of fossil fuels, the energy transition to implementing green energy, including through renewable energy technology, the use of direct air carbon capture and other technologies, and concern about, for example, the mining and infrastructure of minerals that are critical to the energy transition that could have a human rights component. So in that sense, the industries that were really considered for policy consideration by states as part of their assessment of fulfilling their human rights obligations were largely energy, mining, and natural resources. That being said, there are many studies that focus on not just domestic transportation, but also international shipping and transportation in the aviation sector, and of course the whole trade, global trade that relies on shipping on the high seas. And there are studies that are being done about the significant contributions that those industries have. The main points that the rapporteurs would likely make, given the written submissions, is states should consider whether to implement policies that will reduce overall greenhouse gas emissions. That may be in the case of particular governments, that they may need to consider measures in the domestic transportation. When doing so, for example, in the transition to using more electric vehicles, then there will need to be infrastructure components that you mentioned, for example, such as the electric grid, battery charging stations. That cannot be considered in its isolation, though. We would agree with the submission from the rapporteur that you have to be holistic in this consideration, because the mining of minerals that leads to the creation of those batteries that then can be used in public transportation that is decarbonized or lower carbon needs to be considered holistically. One comment that we would say is that most states, when looking at their domestic transportation, should be considering the use of lower carbon technology or decarbonization. We're seeing that in the international shipping industry and transportation, where there's a consideration of using low carbon LNG or greener LNG. Similar considerations should be made in domestic transportation. Thank you.
Well, I would third the remarks that have already been made, and I guess I'll be quite brief. Each sectoral transformation, electricity, transportation, industry, agriculture, and food, to name a few of the big ones, requires a justice and equity lens from a policy perspective and a rights-based lens from a legal perspective. Governments must design and implement programs for the energy transition, which encompasses transportation, for getting heavy industry into low carbon and zero carbon modalities. So transitions and transformations that address the climate crisis while protecting and promoting human rights. But what that's going to mean in each sectoral context is going to be quite distinct, and what it's going to mean in each national context is going to be quite distinct as well. And so, I think I sort of revert to the legal framework seems evident. The policy choices and the technology choices that will be available and are available in each individual instance are going to vary.
Muchas gracias. No sé si tiene alguna consideración.
Thank you. Would you like to add anything? Thank you. In fact, yes, in Mexico, I will talk specifically about the country I'm most familiar with. We have the National Institute on Ecology and Climate Change, which is a government agency responsible for studies and baselines, and in their national inventory on emissions, they have found that the transportation sector is one of the main culprits. The transportation sector is very useful as an example of how important it is to democratize the decisions we're making. Why the government is investing great efforts in regulating private transportation, but is not investing in public transportation. In fact, these measures of this kind would have a much greater impact on mitigating climate change. In this sense, I think when we talk about the transportation sector specifically, we need to understand that there is a need for a human rights perspective in public policy, especially when we think about the impact that policy can have on a large scale. Why is this the case? Because when we are not creating public policies focused on mitigating as much as possible as a human rights consideration, we will have public policies that end up discriminating or creating things that are favorable only to the private sector, in this case, the minority sector. For example, it's beneficial to people who have private transportation, and it offers them more options, but fails to invest in public transportation, which ultimately would benefit more people and would contribute much more to the mitigation of climate change. So it's a very complicated matter. Sometimes jurisprudence or the legal scope of the judges in Mexico has been a limiting factor, or has been limited because the verdicts that are coming out of the courts do not have general application, and therefore they don't provide the answers we need in terms of public policy. Thank you.
Thank you very much, Judge Perez-Goldberg. The fundamental right to lunch will not be violated, so I will ask no questions, and we break until 3 p.m. Thank you.